after the state's first two witnesses of this morning, I believe if we could take maybe a little bit longer lunch break to allow Mr. Cruz and myself to go through and make sure that we have timestamps that connect or correspond correctly. I think that's important and certainly needs to be done, and for the court to hear if there's any kind of disagreement between the parties and what may be admissible before the jury or may not be admissible before the jury. You know, as we've said before, there are many things we agree on. You know, Mr. Faust makes reference to several prior criminal convictions for attempted robbery, burglary, possession of a firearm by a convicted felon, and things along those lines over an extended period of time. And so those things, I don't think there's any argument from the state that those things are not going to be admissible before the jury, but I think that there may be some other things. I just want to make sure that we flesh that out before anything gets played before the jury.
All right, thank you. Ms. Cruz, anything you want to say in response?
No, ma'am.
All right. We will go ahead and do that. I think taking a longer lunch break, if necessary, is appropriate. I'll be downstairs. Y'all need to let me know if we need to take something up on the record before the jury gets back. All right. Anything else from the state?
Nothing else from the state, Judge.
Mr. Cruz, you ready for the jury?
I am, but I do have one matter. Your Honor, the WebEx link, is it possible that I could get that so I can start sending it out to witnesses? One is, I forgot the gentleman's name, but I spoke about him the first day his father died, as well as Ms. Keishana Armstrong, the two individuals that need the link.
And this is for your case in chief, is that correct?
That's correct.
Okay, so the easiest way to make that happen, because it is a very time-sensitive matter and it's hard if we are not in sync with the time that has been set to redo it. So as soon as we know when you're going to present your case in chief, I think is the best time to get those set up.
Yes, ma'am.
All right, but we will certainly do that.
Yes, ma'am.
All right, anything else?
No, ma'am.
All right, thank you. You can bring the jury in. Ladies and gentlemen, thank you again for returning here on time. We are ready to resume the trial, State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready to proceed?
State's ready, Judge.
Is the defense ready to proceed?
Yes, ma'am.
You may call your next witness, Mr. Yolamichili.
State calls Bill Ricketts.
Could you get Bill Ricketts, please?
Sir, if you would, raise your right hand, take an oath. Do you swear or affirm the testimony you will give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would, please speak towards the microphone and just state and spell your name for the record.
William, W-I-L-L-I-A-M, Ricketts, R-I-C-K-E-T-T-S.
Sir, where are you currently employed?
I'm a supervisor with the Department of Homeland Security.
Okay. And what capacity do you, or is there a particular agency that you work with within the Department of Homeland Security?
Yes, sir. I'm a supervisor with the law enforcement section of the Transportation and Security Administration.
Okay. Prior to working for TSA, were you involved in law enforcement in a different capacity?
Yes, sir. From 1992 to 1996, I worked at the Oconee County Sheriff's Office, and from 96 to 2001, I worked with the Athens-Clarke County Police Department.
Okay. And were you working with the Athens-Clarke County Police Department on January 19th of 2001?
Yes, sir, I was.
At that time, what was your assignment or role at ACCPD?
At that time, I was currently assigned with the robbery homicide unit. I was in transitioning out into training at the time, but I was robbery homicide during that time.
Okay. And were you working on January 19th of 2001?
Yes, sir, I was.
All right. So I want to start kind of at the beginning of the day. Did your assignments at robbery homicide take you anywhere outside of Athens?
Yes, sir. That morning I was, I believe it was Milledgeville, Georgia. I was at the state penitentiary working a cold case homicide from, I believe, 1996. I spent the morning there and then drove back to Athens with one of the DA's investigators and came back to Athens that morning. I would say lunchtime or so, somewhere in that ballpark. Maybe.
Okay. And so just to clarify, though, this cold case homicide you were working from 1996, did that have anything to do with an individual named Miss Tara Baker?
No.
Okay. And so when you got back, you said around lunchtime or so, was there anything unusual that you noticed when you got back to the police department?
Yes, sir. When we got back to the police department, pulled in the back where I normally park, and all of our vehicles and forensics and the CID units were gone, which I told the other investigator that wasn't a good sign for us for the day, and it was not. We went inside, and this is early in the days of cell phones, so we went inside, and I got assigned to go back out over to Fawn Drive.
Okay. And you said go back out over to Fawn Drive. Was that related to Miss Baker's murder?
Yes, sir, it was.
Okay. And what did you do when you arrived at Fawn Drive?
I arrived back on the scene and met with Lieutenant Durham. The crime scene folks were there. Talked it outside for just a few minutes with folks there. And then I began to talk to Lieutenant Durham, and he took me on a tour of the scene to get a look around so we could start taking some notes and look around. They had already been working for a pretty good bit of time before I got there. He showed me around the location, the crime scene. We looked at that. I took some notes. And then he kind of put me up to where he wanted me to go start doing some canvassing door to door and wanted me to do some other items that he had on his checkoff list that needed to be done.
So I want to start with your canvassing door to door. Did you speak to an individual by the name of Matt Owens?
Yes, sir.
Okay. And then did you also speak with an individual by the name of Tiffany Riker?
Yes, sir.
Okay. And so as it relates to Mr. Owens, what did he tell you about anything that he may have seen that day?
Objection, hearsay.
Any response to the objection, Mr. Yelman-Chile?
Your Honor, I do believe Mr. Owens testified in this trial, and then Mr. Cruz challenged the credibility of certain things that Mr. Owens had said. So I believe that this would be admissible as a prior consistent statement.
I did not challenge the credibility of Mr. Owens. Mr. Owens testified. I don't even think I asked, well, not even think, I didn't ask Mr. Owens any questions. I just thanked him.
All right, Mr. Yelman-Chile, any response to Mr. Cruz's statement before I make a ruling?
Your Honor, if the defense is contending that he challenged nothing about the truthfulness and accuracy of Mr. Owens' statements, then I don't believe that the prior consistent statement would be admissible.
All right, I'm going to sustain the objection.
Thank you, Judge. Mr. Ricketts, so you spoke with Mr. Owens. We're not going to get into the details of what he said. Did you speak to an individual by the name of Tiffany Riker?
I did.
Okay. What is it that Miss Riker relayed to you?
Objection, Your Honor. Hearsay.
Any response to the objection, Mr. Yelman-Chile?
As it related to Mr. Owens, I don't have definitive memories of the ways in which Mr. Cruz may have asked questions or attempted to impeach that witness, but certainly as it related to Ms. Riker, there were significant periods of cross-examination, including confronting Ms. Riker with previous statements and things along those lines. So I do think that this would be admissible as a prior consistent statement.
Thank you. Yes, sir.
So my second objection based on the state's response would be waste of the jury's time. In regards to our examination of Ms. Riker, the only thing we went through were the statements that she gave to this officer. There was no need to impeach Ms. Riker on her prior statements because the testimony she gave in court, we used her prior statements from the day she spoke with Detective Ricketts to establish what her accurate testimony was.
Thank you, Mr. Cruz. I remember the statements, and I've taken notes on that. I'm going to overrule your objection, allow you to continue with that line of questioning.
So, Mr. Ricketts, as it relates to Ms. Riker, what did she relay to you?
She stated that morning around 8:15 in the morning, she left to go to class. She saw a male subject, black man, walking down the street from the area of Cooper Road towards her apartment. Now, she said the male subject had to stop in order for her to back out of the driveway and go on. Her description, was a medium, average-looking height, medium, no hat, medium hair. It had an orange or bright red shirt, baggy pants, possible jeans, but they weren't dark in color. She gave us that description while we're sitting there talking to her. She was surprised that morning, and it was kind of a foggy, rainy morning that morning. I do remember driving down that morning. I wasn't at the scene during that, but that morning was a heavy fog, kind of rain kind of morning, kind of nasty. And she said it was kind of odd to have somebody cutting through just the apartment area at that time of morning.
And was the unusualness also based on the weather that she described?
She described the weather and then how the subject was almost walked into her car. It was one of those where if she hadn't seen him, she thinks maybe if she had seen him, they might would have run into each other, if that makes sense.
Okay. Did you conduct other canvas interviews?
I did.
Okay. And I'm not going to get into the details of those, but just talking about what you did that day. Eventually, did you end up back at the Athens Clarke County Police Department?
Yes, sir. Lieutenant Durham sent me on several other assignments to take care of, and I did end up back at the police department later that afternoon.
Okay. While you were at the police department, and this would still be January 19th of 2001, is that correct?
Yes, sir, it would.
All right. So while you were at the police department, did you have any contact with an individual by the name of Chris Melton?
I did.
Okay. And who did you understand Mr. Melton to be at the time that you spoke with him?
I had understood Mr. Melton to be the boyfriend of the deceased. From being out at the scene, I had not yet seen or met him at this point, but I understood that's who he was.
Okay. And you said by being out at the scene, to your knowledge, had Mr. Melton been brought to the scene at some point during the investigation?
Yes, sir.
Okay. Do you know the purpose for which he was brought to the scene?
He identified the body, which I was told via digital camera from the crime scene, and was out on the crime scene answering some questions there, I believe, to Lieutenant Durham.
All right. Did you have an opportunity to speak with Mr. Melton?
Yes, I did.
Was there anybody else present when you were speaking with Mr. Melton?
Yes, sir. His father came with him. We weren't expecting him at the police department. He arrived, and he and his father were there together. So we decided to do an impromptu interview there at the office.
And where in the police department in particular did this interview take place, if you recall?
We were kind of over in that forensics area. We were not actually in an interview room. We were over in the forensics office. If you think of it, it's like a small conference room. I won't say a common work area, but a small conference room there where we could have a little bit of privacy and a table where we could sit and talk. The area was pretty busy that whole afternoon. We had several things going on at that same time, but that's where we decided to sit.
Okay. So what, if anything, did Mr. Melton tell you about his relationship with Miss Baker?
So we sat and began to talk.
Your Honor, hearsay.
All right, Mr. Yelmichilli, any response to the objection?
Yes, Your Honor. I believe that Mr. Cruz attempted to impeach Mr. Melton regarding the, status or general place that his relationship with Miss Baker was in at the time. And so I think that these would be prior consistent statements on that issue.
May I respond, Your Honor?
Of course.
During our cross-examination of Mr. Melton yesterday, the exact statement he gave Detective Ricketts about his status, Mr. Melton testified to. My concern, Your Honor, as we just saw with Ms. Tiffany Riker, is the state is attempting to use this officer to change the testimonies of other witnesses. That's why we're raising our hearsay objections. Ms. Riker has testified, Mr. Melton has testified. If it truly is a prior consistent statement that was not elicited or left hanging, which it would lead to a misinterpretation, yes, he could bring it up. But just to ask this officer to follow up and give the same testimony that that the actual witnesses have come in and give themselves, I ask that the Honorable Court, sustain our hearsay objection in that regard.
All right, thank you. Anything further before I make a ruling?
Just briefly, Your Honor, the prior consistent statement rule for admission has to do with exactly the situation Mr. Cruz just described, as far as a witness having testified, the defense attempting to impeach that witness, and then later that witness's prior consistent statements from the time coming in to show that that impeachment is incredible. So it's the very purpose of the rule.
Yes, sir. Yes, sir.
I disagree with that, Your Honor. Okay. Prior consistent statement is if I challenge the credibility of this witness on that statement, and then the state comes in and say, hey, he's elicited testimony that the witness has said one thing, but we have a consistent statement from the past showing that his testimony in court is consistent with the statement that he's made before. We don't have that issue here because Mr. Melton, the same testimony that Detective Ricketts can give to the Honorable Court, Mr. Melton gave. And I can say the statement I won't because I don't want to put any, I don't want to taint the witness. But I would just ask that if there are prior consistent statements that the state would like to use, that's fine. I won't object to those. But just to ask Detective Ricketts what other witnesses told him, we would ask the Honorable Court to sustain our hearsay objection on that ground.
All right, thank you. I think it's the first time in this trial you both are right. You're both correct about what a prior consistent statement is. I am going to sustain and overrule the objection. I'm going to do both. And so this is what I'm going to limit the state to. With regard to the statements that you are seeking to elicit, they need to be connected to the issue of impeachment and any necessity for a prior consistent statement. It cannot be, for example, as Mr. Cruz has just outlined, an entire narrative of the interview with Mr. Melton. So I'm going to ask you to limit your questioning. I'm going to make a ruling that you have to limit your questioning of this witness to the specific areas that you're seeking and arguing need a prior consistent statement.
Yes, Your Honor.
All right.
And so I will not ask the witness, what did he tell you? I will try to be direct, which should give Mr. Cruz an opportunity, if he has additional objections, to bring them up at that time.
That's correct.
All right.
You may proceed.
So, Mr. Ricketts, I want to ask you very specifically, what is it that Mr. Melton told you about the condition or status of his relationship with Ms. Baker at that time?
That is hearsay without exception. I would object.
All right. Mr. Yalamanchili, any response to the objection?
I was just restating the previous question I'd asked, and I think it is directed in the manner that the court informed or instructed me to ask it in order to be admissible as a prior consistent statement exception to the hearsay rule.
Right. I'm going to overrule the objection. You may continue.
And so, Mr. Ricketts, I'll ask you the question again. What is it on January 19th of 2001 that Mr. Melton told you about the condition or status of his relationship with Ms. Baker?
He said they had a serious relationship and had talked and had intentions of marriage in the future.
Okay. And then, I want to take you forward a little bit. We've talked about the general nature and status of their relationship at the time. What, if anything, did he tell you about the plans that he and Ms. Baker had for that weekend?
Objection, Your Honor. Hearsay.
Mr. Yalamanchili, any response to the objection?
Your Honor, again, it is a prior consistent statement. Mr. Cruz, in his cross-examination of Mr. Melton, indicated that at the time leading up to Ms. Baker's murder, the two of them may not have even been in a relationship. He referred to Ms. Baker as his girlfriend or ex-girlfriend. So prior consistent statements regarding the fact that they were in a relationship and had plans together that weekend that both were excited about would be a prior consistent statement that would be admissible.
Ms. Cruz, anything further, sir?
Sure. Mr. Alamachili's purpose for admitting this isn't because Mr. Melton or I elicited inconsistent testimony or inconsistent statement. It's the statement that matters, not the general view, not the general theory of the witness, the statement. We did not get into, on cross-examination, Mr. Melton's plans with Ms. Baker on the weekend after her death or the weekend following her death. We spoke about the relationship generally. So I would ask the Honorable Court to sustain the hearsay objection.
All right. Yes, sir.
And I would just add, Your Honor, the state had opportunity to examine Mr. Melton on direct and redirect examination. I do think it's inappropriate to now try to bolster or support Mr. Melton's testimony through Detective Ricketts, as the jury has had opportunity to hear from Mr. Melton themselves.
All right. Thank you, Mr. Cruz. I'm making a finding that the very issue that the state is asking to have this witness speak about, which is the weekend after the incident, was in fact brought out on cross-examination. The articulation the state has made about what a prior consistent statement is with regard to that issue is accurate, and I'm going to allow you to do it. I'm going to overrule the objection.
So, Mr. Ricketts, I'll ask you again, and I'm trying to make this a specific, tailored question. What, if anything, did Mr. Melton tell you about plans that he may have had and Ms. Baker had for that weekend?
Yes, he went in depth about Tara had plans that evening with friends and family for a birthday party on the 19th for that night, and that he had planned something for her on Saturday night where they were going to meet and be together that evening on the Saturday the 20th.
Did he express anything to you about their feelings regarding those plans?
Yes, on the Friday, numerous times when we were talking, he said that Tara wanted him to drive down and be there for the 19th for the party at the winery with folks in the law school and from the law firm where she worked. He didn't think scheduling-wise.
Objection. I am so sorry, Your Honor.
Okay.
This testimony is an accurate testimony from anywhere in this file. The disadvantage that Mr. Faust has right now when they are bringing in another witness to testify regarding what Mr. Melton may or may not have said, we have no way to cross-examine Mr. Melton on that information. I would ask that the state ask Detective Ricketts questions related to Detective Ricketts' personal knowledge, not information he's heard from someone else, unless it falls under his exception, of course. But to the last question, to the answer, Your Honor, our objection is hearsay.
All right. Thank you, Mr. Cruz. Mr. Yalamanchili, I know the witness is in the middle of a statement, but go ahead.
Your Honor, I think it's the same argument that the court just ruled on, a minute ago, that this is admissible as a prior consistent statement. And I believe it falls within that exception to the hearsay rule, as the court's already indicated.
Mr. Cruz, let me just ask you a question so I understand your objection. Are you arguing that this information was not elicited when Mr. Melton was on the stand?
I am arguing that the statement that was just made from Detective Ricketts doesn't exist in the case file. So I'm saying this is intentional.
I'll let you respond in just a moment, Mr. Cruz.
I'm saying this is intentional from the state. I don't think it's intentional. But what's going on here is Mr. Melton testified yesterday. I'm assuming the state didn't get the information that they would have liked Mr. Melton to say, so they brought in Detective Ricketts to now become a surrogate of Chris Melton, and they'll ask Detective Ricketts, well, what did Chris Melton say about this? What did Chris Melton say about that?
Okay, hang on just a moment. Ladies and gentlemen, I want to take this up outside your presence, all right? So if you'll go into the jury room and don't talk about the case, I'll be with you shortly. Thank you. I wanted to do that in the event, Mr. Cruz, you were talking about things that were not elicited during testimony. I didn't want the jury to hear it if that, in fact, was the case. You may continue your argument. Go ahead.
But my concern is, Your Honor, is the state is attempting to circumvent the rules of evidence by using Detective Ricketts to elicit testimony that, of course, during cross-examination, there's no way I can impeach Detective Ricketts on things that Chris Melton said while Detective Ricketts is on the stand.
I want to make sure I understand your objection, Mr. Cruz. Are you arguing that what Detective Ricketts is talking about right now or about to talk about was not brought up when Mr. Melton was on the stand?
Well, my objection is hearsay.
No, I understand that, but are you also saying that it was not brought up, that particular information was not brought up when he was on the stand, or something different?
Generally, yes, but this wouldn't fall under a prior consistent statement. I didn't get into plans for the weekend. Our entire theory of cross-examination with Mr. Melton was the deterioration of the relationship before her death. The statements, if they wanted these statements from Mr. Melton, they could have talked to Mr. Melton about them. These were, and we could have gotten into it on cross-examination with Mr. Melton. These were outside of the statement that was just made. But as far as Mr. Melton stating, hey, she wanted to see me, we had plans for Saturday, those are accurate statements. As far as, oh, she wanted me to come that night, and we had all this stuff laid out, that's not anywhere in this discovery packet. We looked through all 25,000 pages and 25,000 files. That is not in here. But it would be inappropriate to cross-examine, and let me put it this way. Mr. Faust has the right of confrontation. Mr. Faust has the right to cross-examine statements of witnesses. The state is attempting to use Mr. Ricketts as a surrogate for...
I understand exactly what you're saying, but I want to get I need to understand very specifically what you're arguing. I understand what you're saying about this witness testifying about what other people said, and you're not having the right to confront the actual declarant. I understand that. What I need to know, Mr. Cruz, is what exactly are you alleging does not fall under the exception for prior consistent statements? So you've made two statements. I just want to make sure I understand what you're saying. You are saying, number one, that the information this witness is providing was not in the discovery. And certainly that's one thing. But in terms of this objection, are you also saying that Mr. Melton did not provide it on the witness stand, that this is something you've never heard or something different? That's what I don't understand what you're saying.
Please forgive me for not being...
I mean, that's okay. I just want to make sure I understand what you're saying.
So our specific position is that this is hearsay that does not fall under the prior consistent statement rule. And the reason why we did not elicit a statement from Mr. Melton that was inconsistent with anything they had, I'm going to say allegedly, had planned on Friday or Saturday. My cross-examination didn't even delve into plans because our position, as the Honorable Court is aware, is that they weren't together. So we didn't get into that, we did not get into those statements with Chris Melton. If the state would have liked to get into that with Chris Melton, they could have did it during redirect or direct examination. But I
understand what you're telling me now.
Yes, ma'am.
All right, thank you very much. Mr. Yalamichil, do you care to respond?
Yes, I
Go ahead.
think Mr. Cruz, in part, just made the state's argument for us. He has just said that the entire contention during his cross-examination is that these parties may not have been in a relationship. Mr. Melton did, in fact, testify that he and Ms. Baker had plans for that weekend that he and Ms. Baker were excited about. And then on cross-examination, Mr. Cruz tried to develop a theory that the two of them were not in a relationship. And so that is obviously a challenge to Mr. Melton's testimony that they were, in fact, in a relationship and had plans that they were both excited about this weekend, as Mr. Cruz has just indicated, was the purpose of the cross-examination questions that he asked. So I do think that this evidence is admissible. I would also like to read to the court from Detective Ricketts' narrative talking about the things that Mr. Cruz has been alleging are not in the discovery. Chris told me that Tara was excited about Friday night. It was her birthday, and she was going out with her girlfriends. Chris was going to take her out the next night, which was exactly what Mr. Ricketts was just in the process of testifying to, Your Honor. So, I mean, I understand why the defense doesn't want Mr. Melton's prior consistent statements to come in because they cast doubt on the impeachment mechanisms that the defense has attempted in this trial. However, that is the entire reason that a prior consistent statement may be admissible in the trial of a case when the defense or the state, depending on who called the witness, has impeached or attempted to impeach that witness, Judge. So, I think it's a textbook example of when a prior consistent statement would be admissible.
All right, thank you. Yes, sir.
And I'll just say this, Your Honor. I'll leave
Right.
it to the Honorable Court's discretion.
Thank you. I'm going to relook at the law. I'll be with you both shortly.
To subsection C of 24-6-613, and it will be the second sentence that would.
I've got it, Mr. Cruz. Thank you.
Yes, ma'am.
Going to overrule the objection because this is the law. Just so we're clear. A prior consistent statement shall be admissible to rehabilitate a witness if the prior consistent statement logically rebuts an attack made on the witness's credibility. A general attack on a witness's credibility with evidence offered under Code Section 608 or 609, which is not the case here, shall not permit rehabilitation under this subsection, but we're clear that does not apply. If a prior consistent statement is offered to rebut an express or implied charge against the witness of recent fabrication or improper influence or motive, the prior consistent statement shall have been made before the alleged recent fabrication or improper influence or motive arose. I'm going to overrule the objection. You may continue, Mr. Yelena-Shilly. You may bring the jury in. Thank
You, Judge.
In the restroom? Okay. At ease. We have a restroom moment.
As to the witness, whether or not he would like a glass of water.
Of course.
He got me one. Thank you very much, sir.
Okay.
The ruling that I just made needs to be consistent with the prior ruling that I made when I sustained Mr. Cruz's objection. This questions about questions that the state feels support prior consistent statements cannot be a narrative, just in general. It has to be specifically tailored to the moment in question that the state feels is entitled to be rehabilitated. All right, thank you. You may bring the jury in. You all may be seated. Thank you. Gentleman Chile, you may proceed.
Thank you, Your Honor. Mr. Ricketts, before we took that brief break, I'd asked you a question, and I'm going to try to, as best I can recall, ask you the same question again. Did Mr. Melton talk to you at all or say anything to you about plans that he and Ms. Baker had for that weekend and their feelings surrounding those plans?
Yes. He advised that Tara was very excited about her birthday coming up the weekend, and that she and friends from law school and the law firm she worked at were all getting together at the winery on Friday night, and that Chris had made plans on Saturday the 20th to meet and take her out to celebrate her birthday.
All right. And as it relates to Mr. Melton's whereabouts on Friday morning, January 19th of 2001, is that something that y'all discussed in your interview?
Yes. One of the reasons Friday night that he wasn't going to be down is for work on Friday. The new area where he was working and things of that nature was taking time away. He had jobs to do on that Friday, so he said Saturday would be a much easier thing. And she had her college law school friends and her law firm friends and all to do the dinner with on Friday night.
Okay. Well, and so my question, I might not have been clear in it, and I apologize for that, is did he talk to you about where he was Friday morning?
Yes, he did.
Okay. And what did he tell you about that?
He spent the night and had spent most of the nights that week with his mom and dad, and it was at their residence. I have the address here if you need it, but he was at their residence that night until he went to work that next morning.
Okay, and I don't think we want to or need to say any specific addresses, but when you say until he went to work that morning, did he talk to you about when that was and where he went on that morning of January 19th of 2001?
Yes, sir. He laid that morning out for me. So his morning was to have his helper, his friend Chris, show up to help him that morning at the house there between 7:15 and 7:30, and then they left to start their day.
Okay. Did he talk to you about where they went when they left to start their day?
Yes, sir. His first, on this encounter on the 19th, they stopped at Nash Plumbing first off to load up with gear and equipment for that day for the projects and the jobs that they were going out to do. He said they loaded up to there, and then they were headed over to try to make a stop over at Truck Customs. Chris explained in the interview that he was trying to get a ladder rack put on his truck. They needed to measure it, and then he would go back later in the day and they would install that ladder rack, was my understanding of the conversation we were having. That location is in Loganville, Georgia, and he went there in order to get that measured out. They left there and went over toward Grayson, Georgia, in order to do a job there, check for some leaks, that kind of thing at that house. From there, they went on to Forsyth, met up with a contractor there to look at doing a house there in Forsyth. Now, the house there, I guess it wouldn't have it had boarding on it, but no paper and shingles, I guess, if that makes sense. And I think they were just getting pretty wet. They were going to lay the house out to do the initial plumb of the residence that day. But there was no cover on the roof, so they were kind of getting wet. So Chris stated he went back by Truck Customs just to stop in and see if maybe they happened to be ready on his way back to his house. And when he went back to the house, he just dropped Chris off.
Narrative.
All right, any response to the objection?
Your Honor, I mean, I think it's all still responsive to the initial question of what Mr. Melton relayed to him about what he was doing and where he went that morning.
I am going to sustain the objection. I do think it is a narrative. I'm going to ask the questioner to walk their witness through appropriately.
Yes, Your Honor. Thank you. Mr. Ricketts did, so we're at Truck Customs at this point. Did Mr. Melton tell you where, if anywhere, they went from Truck Customs?
Due to the weather and whatever else, he went back to the residence, dropped his helper off in order to let him go eat and see if they could maybe wait the rain out and see kind of how that would go. He advised that they would meet up together later and try to complete some more work or go back by Truck Customs.
And I'm sorry, let me just ask you some questions as we go along here. You just testified that he had dropped his helper. What was that person's name?
Chris.
Well, Chris Melton.
Oh, I'm sorry. I have to look back. I apologize.
That's all right.
Give me 1 second. I'm so sorry.
Objection, Your Honor. I object on the grounds of hearsay to the witness having his notes while he testifies. If the state would like to refresh the witness's recollection, there's an appropriate mechanism to do that. But for the witness to be able to use his notes while he testifies, that constitutes hearsay.
All right, thank you. Anything from the state before I make a ruling?
I think that's correct. We can go through asking those couple of questions if the court would like.
All right, very good. I'm going to sustain the objection with regard to how to refresh a witness's recollection, but I'm going to overrule the objection with regard to having the report on the stand. A witness is entitled to have it on the stand. They just have to use it appropriately. You may continue.
And so, Mr. Ricketts, before you refer to your report, please, indicate to me that you may need to do that, and we'll go through the appropriate questions.
I understand.
My understanding from your last answer is at this time you can't necessarily recall the name of Mr. Melton's helper. Is that correct?
Yes, sir.
All right. Do you think referring to your report would help you refresh your recollection?
It would.
Okay. Please refer to the report. Do not read from it, and just let me know when you've had a chance to review it.
Yes, sir. His first name is Josh.
Okay. So I think, do you recall now, after having reviewed your report, that individual's name?
Yes, Josh McCurdy.
Yes, sir. Okay. So you had just testified that Mr. Melton dropped Mr. McCurdy off at Mr. McCurdy's residence. Is that right?
They were back at Chris's house. They needed both the vehicles, from my understanding, because Josh went there. But when they went back to Truck Customs, Josh, he was going to have to follow him back to Truck Customs. In order to leave Chris's truck there, they would need the second vehicle. So he went to lunch at that time.
Okay. Did they ever return to Truck Customs?
Yes, sir.
All right. And what did Mr. Melton, what did Mr. Melton tell you about where he went after he left Truck Customs?
He went to Truck Customs, he said around 3:45, 4 o'clock for an appointment that he had there. And he got a page that he received while he was there. He received that page, made a phone call, and then went to Athens to the address on Fawn Drive.
Okay. And this, when you say the address on Fawn Drive, are we talking about Miss Baker's residence where she was killed?
Yes, sir.
Okay. During this interview, this is January 19th of 2001, did you have an opportunity to observe Mr. Melton's hands?
I did.
Okay. What did you observe about Mr. Melton's hands?
During the interview, while we sat and talked, Mr. Melton, for lack of better words, just picked at his hands and messed with his hands, pretty much just gluing things off his fingers from his fingernail beds, and just kind of making that kind of movement while he was moving with his hands. You could see that. And then I had the opportunity to fingerprint him for prints. And at that time, we didn't use computers like we do now. We had to do manual prints, ink prints. So I printed him both hands on the printing, pretty much with a desk just like this. Start with outside and work the inside. So I had to hold and sit and stay there and hold his hands and roll each finger out as I made the fingerprints. And then I would move over to the other hand and do the same exact thing and work through all 5. So all of his fingerprints were done there at the police department after we finished this interview.
And you yourself did that rolling of the prints. Is that what you just testified to?
I did.
Okay. And I just want to go through that process again a little more slowly. Did you just testify that all 10 of his fingers would have been printed? Is
Yes,
that
sir.
correct? Okay. And when you're going through that process, do you make contact with the person you're printing?
Sure. So unlike now, you have to take your hand and you hold the print, the finger, you go to the far side and you roll it because you're getting ink. So now with a computer, you can sit and look at a screen and kind of move it around. But with this, you had to dip his hand in ink. You take it and roll from side to side, and then you would move one at a time from finger to finger. So I dip, roll, dip, and roll, and then get the thumb, and then you move around to the other side. And each time you do that, you have to grab the hand, and you have to hold the hand and do it. And they have to kind of hold their hand real loose and kind of give you kind of control of the hand. It's a much better system we have now. But at that time, I had to sit and hold his hand during that time while we were doing that.
All right. And so I want to fast forward a couple of days and then rewind back a couple of days. Did you have an interaction with Chris Melton on January 21st of 2001?
Yes, sir, I did.
Okay. And during that interaction, did you and Detective Newton take any pictures?
Yes, we did. We took pictures.
Okay. In particular, on Mr. Melton's hands, when y'all met with him on January 21st, was there anything that caused you to take pictures of his hands?
Yes, he had marks on his hand on Sunday that weren't there on Friday evening when we talked to him. And so when we were taking pictures, we took pictures of those also in the rest of his body.
So when you met with him on January 21st and you saw the marks, you took pictures of those, or Detective Newton, y'all took pictures of
Yes, on the 21st, we saw those. We did the other stuff we had to do, and we also took those pictures.
Were those marks on his hands on January 19th of 2001 when you interviewed him and then fingerprinted him?
They were not.
Okay. If they had been, would you have taken pictures of them the way you did on January 21st?
Yes.
Okay. And this is a little bit of an aside. Have you ever worked with plumber's glue and some things related to plumbing?
Sure. So there's primer and there's glue, and the glue gets all over your hands. You have to peel it off, things of that nature. On the interview on Friday, I was just watching individuals we were interviewing, and he was picking at his hands. One, I think, for concentration and trying to cope, if that's a word. I don't know, but he was just trying to pick at his hands and pull that glue off. None of the stuff that I had to do, like if your hands are extremely dirty, like if I got somebody on the street, I needed to print them, I'd have to clean their hands in order to take prints. So there was nothing on his hands that impeded with me taking fingerprints. So I didn't have to go scrub his hands, which I've had to do before, where we've had to get somebody and scrub their hands in order to get prints. We didn't have to do that. Glue primer is usually purple, and I won't say it's see-through, but it's not. It doesn't block, and glue doesn't either. It just peels up, and you have to peel it off.
Well, and let me ask you this question then. Was there anything about the things on Mr. Melton's hands on January 19th of 2001 that would have prevented you from seeing these injuries if they had been there?
No, there was nothing covering his whole. From the picture, you would have had to cover his hand from about where my shirt stops all the way to his fingertips to cover that up, and his thumbs and that area right in there. So you would have had to cover everything.
Okay.
And the plumber's primer and the glue, it gets on your skin, but it's not that bad. I plumbed the house when I built my house. I'm not very good at it, but I got more stuff. But you can see through it. Like if you cut yourself or anything like that, you're going to see that.
Okay. So I want to go forward to January 20th of 2001. So this is the day between the first day in time that you ever talked to Mr. Melton and the second day in time that you talked to Mr. Melton. Did you take any investigative actions in order to, I guess, see if you could talk to some of the people that Mr. Melton had mentioned to you about being with him or around him on Friday morning?
Yes, we made phone interviews on Saturday from the police department.
Okay. As specifically as it related to Mr. Melton's whereabouts on January 19th, who did you talk to on January 20th?
I talked to Josh, and I also talked to Mr. Teeters.
Okay. And you've already testified about who you understood Josh to be. Who did you understand Mr. Teeter to be?
From Truck Customs.
Okay. And is that the Truck Customs that you were making reference to?
Yes, sir.
Judge, I'm going to turn the Elmo off, or can the court turn it off? I just don't want to put something down here inadvertently and have it displayed, because I almost did. Thank you. Okay. Well, and so as it relates to Josh McCurdy, what did Mr. McCurdy tell you about his whereabouts and Mr. Melton's whereabouts on January 19th of 2001?
He drove to Chris's house that morning, approximately 7:15. He said to 7:30, and he said their first stop was at the plumbing. They went there first. And if I could refer to my notes, I can tell you that later. He also mentioned that they went by a Chick-fil-A that morning also.
Do you, and so as you sit here, are you having difficulty recalling the remainder of what Mr. McCurdy told you?
Yes, sir.
Do you believe that reviewing your report would help refresh your recollection?
Yes, sir.
Okay. Would you please do so? Then don't read from your report, but let me know when you finish reviewing.
Yes, sir. So he does mention that they went by Chick-fil-A that morning also for some breakfast.
Did Mr. McCurdy tell you anything about where they went after Chick-fil-A?
To Grayson, which is just right down the road from.
And was there a particular time he said he believed that they had gone to Grayson?
He thought it was between 8 and 8:15.
Okay. And from there, did he tell you anywhere that they may have gone after that?
He mentioned Forsyth and the place with the rain, and he was talking about just how wet they were getting and weren't able to get in and out from underneath that rain. He said that it was just too much rain to get any work done there.
Okay. And so after they left Forsyth, did Mr. McCurdy say anything about where they went next?
He did mention they went back to Truck Customs that afternoon.
Okay. Did they go anywhere between Forsyth and Truck Customs?
He did stop. They did stop for lunch for the lunch break that they mentioned earlier. If I didn't mention that.
Okay. And then did Mr. McCurdy say anything about anything that happened while they were at Truck Customs in the afternoon?
He mentioned the page in detail, and then he talked about how they left Chris's truck there and he drove him to Athens. He didn't want Chris to have to make that drive, but he drove him all the way to Athens.
Did he say anything about any fears that Mr. Melton had or any actions that Mr. Melton took as they drove to Athens?
No, he said while they were in the truck that Chris was calling information, trying to track down other parents of the girls there and trying to make contact as he drove from that area. I'll just say Loganville because it's the easiest there, but as they drove down from Loganville to Athens, he was trying to get information and see if he could make contact with family members.
Okay. And did he say anything to you about any types of worries or fears that Mr. Melton had?
Objection, Your Honor. Hearsay.
In response to the objection.
Judge, under 24-8-8035, past recollection recorded, I believe yesterday during Mr. McCurdy's testimony, The foundation for that was laid, and this would be that past recollection recorded, being admitted under exception to the hearsay rule of 24-8-8035.
All right. Mr. Cruz.
Your Honor, I'm pulling up the law. Okay, so 8035 does not apply in this case. The state, if they wanted to use past recorded recollection, it's not Detective Ricketts who they would use it with. It was Josh McCourty who they could use it with. I'm becoming concerned that the state is trying to use Ricketts to override everybody else's testimony. So I would just ask the Honorable Court to instruct the state not to elicit hearsay. If it's something that's a personal observation of Detective Ricketts, that's lawful, that's legal. As far as just going through witnesses and saying, hey, what do they say about this, what do they say about that, I believe that is improper.
Okay. But your objection is hearsay.
It is.
I'm going to sustain the objection.
And okay, is it so? I'm going to move forward then, Detective Ricketts, and talk to you. You've already mentioned that you had a conversation with Mr. Teeter. Is that right?
That's correct.
Okay. I don't think we need to get into the contents of that conversation, but I do want to go forward with you to January 21st of 2001. Did you have contact with Mr. Melton again on that day?
I did. He voluntarily came back and met with us.
Okay. When Mr. Melton met with you, did he have anybody else present with him?
His family was with him, but they came back with him, but his dad was with him.
Okay. When you spoke with him, and I think you already mentioned taking photographs of him, who all was present when that was happening?
Just Chris and Detective Newton and myself.
Okay. And did Mr. Melton give you any additional information beyond what he told you on Friday evening about where he was on Friday morning?
We went back over the timeline of events from Friday, and Chris added that he had stopped by the Wachovia Bank in Loganville just after 9, which he didn't mention on Friday, which we took note of that. And then on Monday, some other detectives went to run that to ground. That information wasn't passed on a Friday, but Chris talked about it with me on Sunday. Everything else pretty much stayed the same except for that.
All right. And so when he was meeting with y'all on January 21st, did anything come up regarding a blood sample?
Yes, toward the end of our conversation at the police department, we talked about the crime scene, things of that nature. It's the first time that I brought up with Chris that there was the possibility that Tara had been sexually assaulted. We had a brief conversation about DNA and some things of that nature, and I told him that at some point we would need to get consent and he would need to do a sample for us, and he agreed. So a warrant wasn't necessary, but he agreed to go with us to Athens Regional or Piedmont Hospital to do that.
Did you attend or observe that blood draw?
I did. We went there. They followed us over. We had made contact because it was a Sunday, and we had a nurse in the lab do that for us. And I observed both vials be drawn, placed in the evidence bag, and then I took them back to the police department and placed them into evidence.
Did Mr. Melton make any statements to you about the last time he and Tara had sex?
He did. From going over my notes and listening to the recordings, I can't give you a precise date. His voice trails off there, but it was in that week period of time, sometime between that last weekend. I want to say it was Saturday or Sunday would be my best recollection. The recording goes off, kind of. That microcassette recorder's not real good.
Sorry.
That's okay. Sorry, sir.
Off there. Let's talk about the tools that you had in 2001. Obviously, nowadays, we all walk around with these guys that have a recording function on them. When you were a police officer in January of 2001 and you needed to record an interview with an individual, what equipment were you provided with in order to do that?
We were using microcassette recorders. Audio wasn't always the best, but we did pretty good on it. You can listen to them. It's pretty hard to. We used those. I laughed talking to some of the officers waiting for grand jury this morning. They didn't understand that this was the first area of time when we were doing these reports. I know one that was word processing, so if that makes sense, we had done everything else before that on typewriters. So word processing was kind of new, and we were using microcassette recorders, which weren't the great. Athens Clarke County at that time was in the process of putting up interview rooms with video cameras and things of that nature, but they weren't. That was not the norm.
So, I mean, is it fair to say that this was a period of time when, like, the use of technology and the tools that y'all had available was in a period of transition?
Huge.
Yeah. So, as you were there on January 21st, I want to go and retrieve some things from evidence and show them to you. So, if you bear with me for just a moment. Okay. Mr. Ricketts, I'm going to hand you two exhibits. They're both been admitted into evidence already. They're defendant's exhibits 29, and then, I'm sorry, I said two exhibits, two sets of pictures. So D29 has been marked collectively, so all the pictures are D29. And then I'm also going to hand you defendant's exhibit 37, 38, 39, and 40 that have been admitted into evidence already as well. Hand those up to you. I'm going to give you a chance first to look through them, and then if you just let me know when you've had a chance to look through them, I'll continue asking you questions at that point.
Okay.
Detective Ricketts, in the collectively marked exhibit that I handed to you, where there's one number but a bunch of pictures, do you recognize those pictures?
This one right here?
Yes, sir.
Yes, sir, I do. These were taken at Piedmont, Athens Regional.
Okay. And again, who was present when those pictures were taken?
Detective Newton, that's his arm right there in the picture right there. He took these photos here, and I took the other photos.
Okay. And those images, the injuries that are depicted on those hands, were those present on January 19th of 2001 when you interviewed Mr. Melton and then fingerprinted them?
They were not.
Okay. And then the other set of pictures that I handed you, I want to ask you a few questions before we talk about those. I think they're defendants exhibits 37 through 40. if I'm recalling correctly?
Yes, sir.
Okay. When you noticed those injuries to Mr. Melton's hands, was there any explanation provided by him for where those injuries came from?
I talked to him about those. He advised that when he got back to his apartment, went in, was alone for a period of time, that he kind of lost it. He said as soon as he walked in the door, it was there on the right side when you go into his apartment, and he just punched the wall numerous times. And then he said he sat on the floor and just cried.
Did you ever go to Mr. Melton's apartment after you talked with him about those injuries and how he received them?
So I believe it's the 23rd. Went over. I believe that's the correct date. But yes, sir, I went and I took these photos in the apartment.
Okay. And when you say these photos, are you referring to defendants exhibits 37 through 40?
I am.
Okay. The damage that you saw to the wall, was that consistent to you with the injuries that you saw on Mr. Melton's hands?
It is.
Okay. Detective Ricketts, thank you so much for your time. I don't have any other questions for you right now, but I'm sure Mr. Cruz may have some.
Yes, sir.
Cross-examination, Mr. Cruz.
Before I cross, may I use the bathroom? Your Honor?
Yes. Why don't we take a 10-minute recess and allow everybody to use the restroom? We'll be off the record until about 10:25. Thank you. Don't discuss the case. We'll see you all shortly. Back on the record, you may bring the jury in. Thank you. You all may be seated. Mr. Cruz, cross-examination.
Good morning, Detective Ricketts.
Hey, good morning.
My name is Attorney Amai Cruz, and I have the privilege and honor of representing Mr. Faust. Under the authority of this honorable court, I'm going to ask you some questions. Is that okay?
Yes, sir.
Okay, excellent. Detective Ricketts, you were with ACCPD, is that correct?
That's correct.
Okay, and during the time of this investigation, you were with ACCPD. Is that right? Would you agree that ACCPD dropped the ball on this investigation?
No.
Okay. You believe ACCPD followed up on all leads,
Yes.
confirmed all information?
I think so. I would like to add something to that if you would allow me to.
I can't answer any questions. We could talk about it after, though, if that's okay. This time,
No, I think I'll answer that question. Yes, I wish if you look back at any case 25 years ago and look at it with fresh eyes from 25 years ago, yes, things would have been done totally different, I think, with some options and things that would have happened. Everything that I can say to, and I will not answer on behalf of ACCPD, but on the days that I was a part of this case, I will say, I think, yes, we did. But I think if you look at anything 25 years back, I think if you look at something I did last week, there would be things that I would like to improve on.
Okay.
But I don't think drop the ball would be a word I would ever use.
sure. Do you believe ACCPD followed the evidence appropriately?
Yes, sir. The evidence, to my knowledge, I believe they did.
Okay. And I'm assuming that you met with the prosecution before you testified today. Is that right?
That's correct.
Okay. Do you or ACCPD feel a need to justify why Chris Melton was not arrested?
No.
Do you or ACCPD feel the need to have to defend Chris Melton?
I don't believe I'm here defending Chris Melton.
Sure. So that is a yes or no question.
Then please repeat it.
Yes, sir. Do you or ACCPD feel the need to defend Chris Melton?
No.
Okay. Do you or ACCPD feel the need to defend the state's case?
No.
Okay. So I'd like to ask you some questions about a couple of things that you talked about on direct examination, okay?
Okay.
For starters, would you have any reason to disagree that January 19th, 2001 was 9,153 days ago?
Sounds appropriate.
Okay. And I'm going to use this whiteboard over here.
Yes, sir.
So 9,153 days since 1/19/01. Fair?
Sounds correct.
In 2001, can you tell us what team won the Super Bowl?
I cannot.
Okay. In 2001, can you tell us what team won the World Series?
No.
In 2001, can you tell us what your favorite song was?
No.
Okay. So no to Super Bowl, and forgive my handwriting. It is terrible. No 2 World Series. Know the favorite song. My handwriting is terrible. And this is know the favorite song. Correct. And you would agree that your notes say nothing about Mr. Melton picking anything off of his hands. Is that correct?
No, sir. I'm going with that from the recollection of the audio cassette tapes from that day.
So your statement to this jury is that based on the audio cassette of that day, it refreshed your recollection that Mr. Melton was picking items off of his hands.
Yes, sir. You asked me about the Super Bowl. Not an NFL guy, not a baseball guy.
That's fine.
The crime scene for Tara Baker, I'll never forget.
Mr. Ricketts, that's a yes or no question.
Well, repeat your question, please.
Witness is allowed to explain his answer.
May I be heard on that, Your Honor?
You may be, yes.
I would disagree with that. The witness on cross-examination, my job is to posit to the witness yes or no questions. If the state wants the witness to elicit further testimony, they do that on redirect. At this time, Your Honor, I pretty much give the witness what the answer is. They can answer yes or no, and we decide which direction we go from there. So I would ask that the witness is not allowed to control cross-examination, to control Mr. Faust's rights to cross-examination, and we're allowed to ask the witness leading questions that the witness answers appropriately.
Okay, so this is not about witness control. This is about what the law allows. And cross-examination questions are yes or no questions, certainly. But the law allows a witness to answer yes or no and then explain if he or she chooses to make an explanation. And so I'm going to overrule your objection. He is allowed to explain if he chooses to. If there are further objections the court needs to make with regard to those explanations, I certainly will hear it.
Yes, ma'am.
If you'll ask the question again, Mr. Cruz. Thank you.
Sure. And I withdraw that question, Your Honor. I withdraw that question. But my understanding is the audio is what refreshed your recollection in regards to what was on Mr. Melton's hands.
Yes,
Okay. And that audio is from January 19, 2001.
that's correct.
Okay. And you've already listened to that audio because the state provided you with a copy. Is that correct?
Yes, sir.
Okay. And if you were to hear that audio, you would recognize it. Is that fair to say?
Yes.
Okay. Court's indulgence. Turn the volume down on this. I'm going to move the mic out the way.
Okay.
I'm going to allow you to hear the audio. I want you to listen to it. When you feel comfortable that you recognize the audio, just look up, okay? Is that fair? Is that fair?
Yes, sir.
May I approach the witness, Your Honor?
Right.
Yeah.
I'll turn it down. Sounds like something's playing. Give me one sec. And here you go. And if you need to turn it up just a little, you can press that button right there. You can turn it up if you need to. Correct. If you recognize it, if it's accurate, what you recognize it as.
This sounds like the beginning of the audio from the 19th.
Correct. With you and Mr. Chris Melton?
Yes, sir. His father.
Okay, that is fair. Does that sound like a fair and accurate rendition of that recording as you remember it? Now, what I'd like you to do, I'm going to mark that flash drive, which has been identified by the witness as the interview between Detective Ricketts and Chris Melton on January 19th, 2001, as Defense Exhibit 44. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 44. All right, so this is what I want us to do with Defense Exhibit 44. Detective Ricketts, I'm going to allow you to listen to this, okay? And can you look up at the portion where you discuss with Chris Melton what's on his hands? Is that fair?
Yes.
Okay. And just to make sure we're clear, this recording, based on your prior testimony, this recording refreshed your recollection about Mr. Melton picking his hands, what was on his hands, things of that nature. Is that fair to say?
Yes.
Okay, excellent. May I approach the witness, Your Honor? Okay. There you go. And I just stopped it where you stopped it. So if you...
Okay.
And if you would, once you hear that portion of the recording, just let us know the timestamps.
If that was anything. Like, I thought that, that's why we didn't say that.
Okay. That's that. You turn audio up as you need it. Your choice. If you could find it by speeding through it, we'll take that. If you need to listen to it, we'll take that. We just want to know where in that recording do we talk.
My recollection is toward the very end of the interview, which is pretty lengthy.
You can speak through it. I think it's I could give you the times for the ending of the interview. But yes, you can speak through it. All right, and the interview ending time is 42:08, if that will help you. 42:08 is the interview ending time, if that will help you. And Your Honor, if you would like to just avoid the jury sitting in the box, if you would like to give them a break while Detective Ricketts looks over that video, I have no objection to saying.
Thank you.
Yes, ma'am. Would a transcript help you find it faster, Detective Ricketts? Sure. I have a transcript for you as well.
Mr. Cruz. Total length of the audio I have is only 26 minutes. I don't.
Can you go to minute mark 40:48 through 40:49? Or 40:48, start at 40:48 and play it to 40:51. Justin, I'm gonna need you. Thank you. Did you hear it? Yes. Okay. And you would agree that the statement that you made that led you to say that Chris Melton was picking things off of his hand, that he had different glues on his hands, was you need to wash those things up or anything. Is that correct?
Yeah, I believe I said, do you want to wash those things up? Is that...
Okay. Can you write that on the board? Do you want to wash those things up?
Yes,
okay. And that is minute mark, you would agree, 40:48 to 40:51?
Yes, sir. That was helpful. Thank you.
You're welcome. Your Honor, I would move to admit defense exhibit 44 for the purposes of moving minute mark 40:48 through 40:51 into evidence.
Any objection?
No, Your Honor.
It is admitted.
Thank you, Your Honor.
And just to clarify for the record, is it my understanding, Mr. Cruz, that you're just seeking to admit those 3 seconds of the recording?
Right.
Okay.
For now, we're gonna admit more, but for now, just those 3 seconds. So, the statement, do you want to wash those things up? It says nothing about picking at fingernails. Is that correct?
It's correct.
Okay, and we've agreed that it's been 9,153 days, right?
Correct.
It says nothing about picking paint off of his skin or picking glue off of his skin. Is that correct?
No, sir.
Okay, it says nothing about whether the glue was transparent or not, does it?
No.
Okay, would you be shocked to learn that Mr. Melton testified himself that he had plumber's cement on his hands?
No.
Okay, but that would be inconsistent with the testimony that you just gave the jury here today. Is that correct?
No, plumber's glue, plumber's cement, I would categorize as the same thing.
Well, he said 3, and he included plumber's glue.
Okay.
Okay. So would that testimony differ from the testimony that you just gave the jury on direct examination?
I don't think so.
That's fair. 9,153 days. We don't remember the Super Bowl. We don't remember the World Series. We don't remember our favorite song. But the simple statement, do you want to wash those things up, led you to tell the jury that Chris Melton's hands, you could see them. Is that right?
Yes, sir. It was the totality of this interview, sitting in that interview room, looking across the table at a dad and a son. And Chris, as he would make comments, you can hear that. He'll tone in, tone out, not a person to show emotion or things of that nature, but would sit and pick at his hands and pull. And it was just, I won't say a nervous tick, but it was what he was trying to do, I think, to keep his focus, would be my opinion. That is what we're talking about with there. We're ending the end of the interview where I've got to get fingerprints, and I just asked him, hey, do you want to wash those things up? Do you want to get that stuff off of there? That's all it was. If he'd have had a high amount of semen or whatever else on his hands.
Objection, non-responsive and narrative.
I'm going to sustain the objection with regard to non-responsive, the end of this particular statement. You may continue.
Sure. What you just stated, that's nowhere in the police report, is it?
No,
You have your reports, is that right?
that's correct.
It is not in the audio recording you heard, is that correct?
That's correct.
Okay. And as far as the evidence that you've personally provided in this case, the very first time you've ever made that statement is before this jury here today, is that correct?
What do you mean?
Sure. Based on your notes and based on the audio recording. You have never said before that Mr. Melton was picking at his hands, picking items off of his hands. Is that correct?
No.
Okay. But we would agree 9,153 days later you stated. Is that correct?
That's correct.
Thank you. Now, you also stated on direct examination that Mr. Melton wanted Miss Baker at his, excuse me, let me rephrase that. You also stated on direct that Miss Baker wanted Mr. Melton at her birthday party on Friday. Is that correct?
That's correct.
Did you interview Miss Virginia Baker?
No, I don't believe so.
Okay. So you're not aware that, but you did not interview Miss Virginia Baker, is that correct?
No, the only people I did were some roommates and other folks who corroborated what Chris said for me there.
Okay. Do you know if Chris Melton had talked to those roommates and told those roommates the same thing he told you?
I would have to look at my notes, but one of them mentioned it to me in her statement, I believe.
Sure, look at your notes. And tell us the date that she mentions that.
Give me one more second, just make sure I would give you a good, direct answer.
Absolutely.
So those statements aren't going to be about the birthday party, and I don't know if you want me to read what I've got about the relationship with Tara. I don't want to say it. So
Well,
I don't have anyone doing what you said. So I'll say no to that because that's on a different relationship page. I don't know if you want me to bring that up or not. So
no. So the specific answer to my question is no. No one else said anything about Mr. Melton's.
to my knowledge, no, then it was a different statement.
So the statement that you gave on direct is inconsistent with your notes.
Which was the statement I made on direct? It's,
that Mr. Mr. Melton and Ms. Baker had plans on Saturday. Is that correct?
that's correct.
Okay, and I asked you, and I'm gonna paraphrase it, had that been corroborated by anybody else? Is that correct?
That's correct.
Okay. And your answer to that question is no.
Yes, that direct question, yes.
Okay. So you just simply took Chris Melton's word for it. Is that fair to say?
Yes, that was my point there.
Do you think in a criminal investigation, especially involving murder, aggravated assault, burglary, aggravated sodomy, arson, it is important to take more than someone's word for it? Is that fair to say?
Yes.
And I believe the question I asked you was about the party Friday. That's what we were talking about, not Saturday, the party Friday.
Yes, sir.
So just to clarify the record, the fact that Tara wanted Mr. Melton at the party Friday, that was based on Mr. Melton's word. Is that correct?
That's correct.
Okay. And the same for Saturday. Is that right?
Yes.
Okay. And Mr. Melton did not provide any proof of any plans he had with Ms. Baker. Is that correct?
Did not.
Yeah, I'm going to go into a line of questioning that the Honorable Court has advised us to be cautious about. Can me and Mr. Yalamachili approach the bench, please? All right, so you know Mr. Melton's parents' address, is that correct? Okay, you don't have to say the address. And Ms. Baker's address was 160. Your Honor, I am asking the Honorable Court to take judicial notice under OCGA 24-2-201B 2 of the distance between Mr. McCourty's parents' home and Ms. Baker's home.
Judge, judicial notice does not bring a fact before a jury as a trier of fact in a jury trial. It is just something that the court can take notice of. It is if it is a previously established fact. So the method in which Mr. Cruz is attempting to use judicial notice, I don't think is proper.
That is not true, Your Honor. I have case law 1, but I'll read the statute. The statute provides B, a judicially noticed fact shall be a fact which is not subject to reasonable dispute, in that it is either, and we're under subsection 2, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. And C says a court may take judicial notice whether or not requested by a party. And D is the language that, shows that the state's argument is not the law. A court shall, is no discretion here, a court shall take judicial notice if requested by a party and provided with the necessary information. The limitation that the state just put on the Honorable Court's ability to take judicial notice is not a limitation in the law, Your Honor. We're relying on the statute. We would like to show the state, if okay, the statute as well as the item we would like judicially noticed.
I'm familiar with the law, Judge.
And may I approach, Your Honor? Approach you.
May you approach the court?
Yes, ma'am, to provide you with these documents and the law.
I don't need the law, Mr. Cruz. Any other arguments, sir?
No, ma'am.
All right. I'm going to sustain the state's objection. I agree with the state's rendition of the statute and the appropriate things that are to be used for judicial notice. I'm going to sustain their objection.
Yes, ma'am. Do you have your phone?
I do.
Okay. Can you go to Google for us, please?
I can turn it back on. It's off. Is that okay with the court?
I don't have any prohibition against that.
Okay. I have it on flight mode.
I'm not objecting in this trial. If there's an objection, I will hear it.
I just don't want to upset you, ma'am.
No, sir. Thank you.
Okay, I've got a signal now.
Okay. Can you go to Google Maps or whatever you use, Apple Maps, Google Maps, whichever you prefer?
Okay.
And I'm going to approach you. Sure. And for the purposes of the record, I am going to provide Detective Ricketts with Chris Melton's parents' address. Can you put the distance from Melton parents to Tara's home? Yeah, under law.
Give me the directions.
Don't give me the directions. Do you have it pulled up?
I have the address.
All right, and do directions to 160 Fund Drive, Athens, Georgia, 30605. Chris Melton's parents' home. And when you pull it up, I won't ask you about the time. I believe that that's not competent evidence, but I am going to ask you about the distance. Is that fair?
Sure.
Okay. All right. Tara Baker's home. You would agree that on one route, the distance from Mr. Melton's parents' home to Miss Baker's home is 39.6 miles. Is that correct?
Yes, sir. I'm getting an ad pop up, but
Sure. Circle.
yes, sir. I'm getting 40 miles.
Okay. 39.6 added up, 39.9 rounded up. Excuse me, rounded up. Okay, perfect. All right. And I want to be specific. So 39.6, is that correct?
Yes, sir. This Google's giving me 40 on the nose.
Even?
Yes, sir.
Okay, we'll take what Google gives you. Put 40 miles.
I can switch routes and stuff for you if you like.
No, you're fine. All right. Do you recall talking to a Mr. Lindsay Baker?
I'd have to look at my notes to double check.
Okay, sure. And I don't believe that would be in your individual reports. And I don't know what all notes you have, but
I pretty much only have anything that my name is on. I don't have anything.
anything else? Well, let me ask you this. Do you know who Mr. Baker is?
No, sir.
Okay,
Off the top of my head, no, sir.
that is fine. Did you ever visit Mr. Melton's parents' home?
I did not.
Okay, but he did tell you at the time that Miss Baker was killed, he was staying at the parents' home. Is that right?
Correction. Could you repeat that question for me one more time?
Sure.
Did you say the Baker's residence?
No, and I might have said the Baker's
Yeah, I think
residence,
so.
so please forgive
You
me.
go to the Baker's home.
The Melton residence.
No, I did not. Someone else did that.
Okay. So you don't know the layout of the home?
I do not.
Okay. But Mr. Melton did tell you he was staying in the basement of the home. Is that right?
No, he just told me he was staying there. He never told me where in the house he was staying. He just said he was staying at his parents' house. And on that same audio, you can hear his dad at the beginning say he's been staying there for pretty much the week.
Okay.
Hear him chime in.
But to your personal knowledge, you don't know where in the home he was
No, I don't have any information on that. May I turn my phone back off?
Absolutely.
Because it will.
Now, you had opportunity to listen to the recording between yourself and Mr. Melton, right?
Yes, sir.
And we've agreed that that interview took place on January 19, 2001. Is that right?
That's correct.
And you asked Chris during the interview, how did you start your day today, or what kind of went on today for you? Do you recall asking that question? And Chris was able to explain his day in a calm and clear tone. Is that correct?
Yes.
He was not unable to answer any question. Is that correct?
I believe everything I asked him, he did answer.
Okay. He was not fumbling over his words. Is that right?
No, there are times in that recording that he will get quiet. He won't say anything.
Okay.
But he was able to get through his conversation.
But we could both agree that he wasn't frantically crying. Is that right?
No, he was not.
But he did tell you that he was asked to identify the body that day. Is that right?
That's correct. Earlier in the day.
Okay. And we agree that Ms. Baker died on the same day. Is that right?
That's correct.
And he also described her as his borderline fiance. Is that correct?
That's correct.
He even spelled the name of Truck Customs for you. Do you recall that?
I did. I was having an issue with it. I believe in that tape, I asked him to spell it for me.
Mm-hmm.
It could be the second interview I did because I was having a hard time finding it. But that could be the second interview I did with him where I asked him to spell it.
Would hearing the first interview refresh your recollection? Or would, excuse me, let me change that. Would hearing him spell out Truck Customs refresh your recollection?
Sure, if that's in the first one, I'll just agree with you. It did. He did spell it for me in one of those two because in my report I had it wrong.
Sure.
And I had to get it corrected.
So let me ask the question this way. You would not disagree that on January 19, 2001, Mr. Melton spelled out Truck Customs for you during that interview?
I would agree with you on that.
Now, while detailing his day, Chris stated that Josh came to his house after he woke up on the morning of Miss Baker's death. Is that fair?
Say that one more time.
Sure. While he was detailing his day to you, he stated that Josh came to his house on the morning of Miss Baker's death.
Yes, sir. That's how I took it.
And Chris stated that him and Josh only work together. Is that correct?
What do you mean by only work together? It's the two of them?
They
or-
don't have any personal relationship. Is that correct?
He advised that they work together, yes.
And the address Josh came to pick up Mr. Melton was from Mr. Melton's home. Is that fair to say?
That's correct.
Okay. And we've discussed that address. And they drove to a company called Nash Plumbing together. Is that
Correct.
correct? And this was in Chris's truck.
That's correct.
Chris says that they arrived at Nash Plumbing between 7:35 and 7:40. Is that right?
Yes.
Pen. Thank you. And he stated while at Nash Plumbing, they loaded up. Is that correct?
We went there to get their supplies.
Would you agree that during the course of your investigation, you were unable to speak with any supervisor that confirmed that Josh and Chris were at Nash Plumbing between 7 a.m. and 9 a.m. on January 19, 2001?
That's correct. I did not do that.
You were unable to speak with any coworkers that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
That's correct. I was not assigned to do that.
You were unable to speak with any receptionists that could confirm that Josh and Chris were at Nash Plumbing between 7 a.m. and 9 a.m. on January 19, 2001.
That's correct.
You were unable to speak with any eyewitnesses that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001.
That's correct.
You were unable to obtain any sign-in logs or visitor logs confirming their presence at Nash Plumbing at all on January 19, 2001.
You're correct.
You were unable to obtain any business records that confirmed that Chris and Josh went to Nash Plumbing on January 19, 2001.
Yes, that's correct.
Now, Chris claimed they loaded up. We've agreed on that. Is that right?
Yes, sir.
But you were unable to obtain any signed delivery or pickup receipts that supported that Chris was at Nash Plumbing on January 19, 2001. Is that right?
That's correct.
You were unable to obtain any invoices supporting that Chris Melton was at Nash Plumbing on January 19, 2001. Is that correct?
You're correct.
And although they picked up supplies, you were unable to obtain any work orders that supported that Chris was at Nash Plumbing any time on January 19, 2001.
That's correct.
Now, in regards to Chris and Josh saying they worked together, Chris told you that Josh was his employee. Is that fair to say?
Yes.
Okay. You were not able to obtain any payroll stubs to confirm that they were employed together, were you?
Yes, sir. I was not assigned to do that.
Is that a no?
Yes, it's a no.
You did not collect any W-2s or 1099s confirming their employment together?
I did not.
Mr. Melton didn't even provide you with an employment contract showing that those two worked together.
No, he did not.
Did you obtain any work-related emails between the two?
No.
And I know it was 2001, but you didn't collect any work-related text messages between Josh and Chris.
No, sir.
Correct? You were unable to interview any third-party co-workers that confirmed that Chris and Josh worked together. Is that correct?
That's correct.
And Chris's father was with Chris during the January 19th interview. Is that right?
He was.
And during that interview, not even Chris's father confirmed that Josh and Chris worked together. Is that correct?
No, he was not asked to.
So we simply took Chris Melton's word for it.
At that point of the interview, that's what I did. Other folks were assigned to follow up on those things.
Yes, sir. Now, during your interview with Chris, he told you that his home and Josh's home was less than one mile apart. Is that correct?
I don't know if he gave me a direct. He did say they lived near each other,
Okay.
if I recall that correctly.
Do you recall Chris stating, drove back to their house, talked to let Josh off that little guy. He lives like a mile from me. Do you remember?
Yes, sir.
And obviously, Chris knew where Josh lived. Josh knew where Chris lived. Is that fair?
Yes, sir.
Okay. And Detective Ricketts, you personally never investigated whether Josh and Chris were personal friends. Is that right?
I did not.
Now, Chris stated after going to Nash Plumbing, he went to Truck Customs. Is that fair?
Yes. If you'd like to refer to my notes, but yes, that would be the second location.
Yes, right where it gets at the bottom. And you go to the next page. We're going to start at the top. Question for you, Detective Ricketts. Have you met with the state in this case?
I have.
Did you take notes of your meeting with the state?
I did not.
And then we'll go to the next page. All right, Detective Ricketts, what we're going to do for purposes of the record, I have a whiteboard here. We're going to write your name at the top, okay?
All right.
And we're going to discuss the information that you were given. Is that fair? All right, so Ricketts at the top. Two T's. You write it big. All right. Then put an underline here. And we're going to write Chris. And we're going to write Josh. All right. Then a line down. And then write Chris here. Write Josh there. Thank you for your patience.
No worries.
All right, so we're going to write, and you let me know if this is accurate. Very first place Chris says is Nash Plumbing. Is that correct?
Yeah, on the 19th?
Correct.
Yes.
All right, can you write Nash Plumbing here under Chris?
And for purpose of this, you may want to put the 19th on there because on the 21st, he added a location. So I don't know if you want to differentiate that or not.
So the first place is Nash Plumbing.
Yes, sir.
Okay. All right, put a hyphen at the Nash Plumbing. And Nash Plumbing was unconfirmed. Is that right?
By me, yes, sir.
Okay. And put unconfirmed after the Nash Plumbing. I'm about to go fast, okay. All right, after Nash Plumbing, he stated that he went to Truck Customs. Is that correct?
Can I? Yes, Truck Customs is number 2. Yes, sir.
Truck Customs. And he stated that they went to Truck Customs at 9:30 a.m. or earlier.
May I refer to these?
Absolutely. And Detective Ricketts, to be fair, you can use the 19th or the 21st, whichever one you would like to use as far as the
He said around 9:30. Yes, sir.
So put 9:30. And I want to emphasize this language. He didn't say 9:30 or later. He said 9:30 or earlier. Is that right? And it's page 1 of 2.
He says, or maybe earlier. Yes, sir. You're correct.
Or earlier. Now, after leaving Truck Customs, Chris advised that him and Josh went to a home in Grayson. Is that correct?
Yes, that's correct.
And forgive me, we skipped something. He eventually tells you that he went to the bank, right?
Yes, sir.
Just put bank right there. Bank right here. Did you speak with anyone other than Josh to confirm that Chris was in Grayson, Georgia on the day of Ms. Baker's murder?
I did not.
Did Chris provide any documentation confirming that he worked on or went to a home in Grayson, Georgia on the day of Ms. Baker's murder?
To me, no.
Okay. So just for you, we just took his word for it. Is that right?
For this on the day of, yes, it's preliminary, and then Sunday the same.
Yes, sir. You can put Grayson, Georgia after Truck Customs. Now, excluding Grayson, we could safely say that Ms. Baker was killed between 7 a.m. and 11:32 a.m. Is that a fair window? And I can ask it a different way. At 11:32 a.m., the fire was reported. Would you agree with that?
Fire was reported at, I don't have notes on this, but at 9:00 whatever, the clock on her wall no longer worked.
Okay, perfect. That's fine. We could say 7 to 9, whatever. So we'll say 7 a.m. to 9 a.m. Is that
I would
fair?
be more comfortable at that time.
Okay, excellent. And you're aware at 7:45 a.m., a neighbor of Ms. Baker said they saw a white guy running through their backyard away from Ms. Baker's home. Is that correct?
Yes, that's not in my interview,
But you are aware of that?
I heard that, yes, sir.
Okay. So it's safe to say that if that person was the murderer of Ms. Baker, it's safe to say that the murder occurred before 7:45 a.m. Is that correct?
If that's the murderer.
Correct. Is that fair to say?
Yes. Could be, yes.
So you knew that it was very important to confirm where Chris Melton, well, let me change that. It's fair to say that it would be very important to confirm Mr. Melton's whereabouts before 9 a.m. Is that fair?
Yes.
And for his alibi, he says, I start my day at my parents' house. Is that fair? And between, because this is a specific time, he says between 7:35 and 7:40, right? At Nash Plumbing, is that correct?
7:30, 7:45.
Okay. So based on what he told you, he's saying I'm either at Nash Plumbing or I'm at Truck Customs. Is that right? 9:30 or earlier. Is that correct?
Yes.
So after speaking with Chris, ACCPD's job becomes confirming Chris's alibi. Would you agree?
Yes.
Because if his alibi is false, would you agree that would suggest consciousness of guilt? Is that fair to say? Let me rephrase it.
Yeah,
let me rephrase it in a better manner. If Chris Melton lied about his alibi, that would be significant in your investigation. Is that fair to say?
Yes.
Now, we can agree that you actually took the next steps to trying to confirm Chris Melton's alibi. Is that fair?
Yes, I was part of that, but there were other detectives doing that also.
Yes, sir. You spoke with Josh McCurdy. Is that correct?
Yes.
You spoke with Mr. Bill Teeter. Is that right?
I did over the phone.
Okay. And you spoke with Josh McCurdy not on the 19th, but the next day, January 20th.
That's correct.
And it goes without saying, but it's the day after Miss Baker's death.
That's correct.
Now, Josh also told you they started their day at Nash Plumbing. Is that correct?
Yes.
Okay. And you'll put Nash Plumbing here. And we've agreed that Nash Plumbing was unconfirmed.
From me, yes.
And if you put unconfirmed next to Nash Plumbing. Then after leaving Nash Plumbing, Josh says we go to Chick-fil-A for breakfast. Is that fair?
Yes, Josh brought Chick-fil-A up.
Say that one more time.
Josh brought Chick-fil-A up.
Thank you. And if we could write Chick-fil-A under Nash Plumbing. And then Josh says at around 8 a.m., they went to a house in Grayson to check for leaks.
Yes, he gave 8 a.m. checking for leaks.
Okay.
Said behind the fire department on Georgia 20.
And I think we've already agreed Grayson, Georgia is unconfirmed for Chris. Is that right?
From me, yes.
If you put unconfirmed there. And then Grayson, Georgia here, unconfirmed. Or Grayson, Georgia, 8 a.m. And then Josh says from Grayson, they go to Forsyth.
That's correct.
And did you confirm that Josh or Chris Melton were at Forsyth?
I did not.
Okay. Now, they did provide you with the name of Truck Customs. I believe he may have even provided you with the address to Truck Customs. Is that correct?
He may not have advised me of it, but we did get the address for Truck Customs.
Perfect. But he didn't provide you with the names of anybody he spoke with in Grayson, did he?
Grayson, no. I don't know if he did with other detectives, but he did not with me. That's not what was your.
So Grayson is unconfirmed, Chick-fil-A is unconfirmed. Is that fair?
That's correct.
Okay. You put unconfirmed there.
That
For Grayson is unconfirmed, Chick-fil-A is unconfirmed.
just by me, so you got my name on it. So yes, sir, that's correct.
Correct. So you would agree between 7 a.m. and 9 a.m., both Chris is unaccounted for by you and Josh is unaccounted for by you.
I have both their statements given at different times that corroborate where the other one was. So on this preliminary part of the investigation, we had a general idea of where they were, and that's what we were going with at that time.
Well, when it comes to murder, aggravated assault, aggravated sodomy, we want to have facts. Is that fair to say?
Correct. And in this early stage, the 19th, 20th, 21st, we're trying to get information on 3. So a lot of times when you're taking these cases in the first, you'll get somebody says this, as Chris did. He left information out on Wachovia, remembered it. Now, people forget things like that all the time. You've got Josh's, and then you interview these other ones, and all you're doing is taking and aligning their timeline. During that first 3 days, that's what we were doing, is just aligning that timeline and getting the stories where everybody was, and then getting DNA, fingerprints, and things of that nature in order to work the case to push on to the crime lab.
Correct. So I ask you this. At that time, you were a law enforcement officer. Is that right?
That's correct.
And your job was to protect this community. Is that correct?
Yes, sir.
So as we talk today, why are you defending Chris Melton?
I'm defending the information that I gathered on the 19th, 20th, and the 21st.
Well, wouldn't it be an issue if Chris Melton says that they went to Grayson after 9:30 and Josh McCourty says that they went to Grayson at 8 a.m.?
Yes, but from the Wachovia video and whatever else, we've got that stamp at 9:08.
You're aware of the Wachovia video, is that right?
Yes, sir.
Okay, but our timeline is 7 a.m. to 9 a.m. 9:08 is outside of our murder timeline. We're saying 7 a.m. to 9 a.m. Josh and Chris are unaccounted for. Is that fair?
Well, yes, if you want to say it that way, but to be in the Chick-fil-A is right next door to that also. To be in that area in under an hour and 15 minutes from Fawn Road in Athens on morning rush on a Friday, it's going to be very difficult to do.
My question again, why are we defending Chris Melton?
Again, I'm defending what we were doing in these first 3 days of this investigation.
But Detective Ricketts, you've told us that Chris's parents' home is only 40 miles away from Miss Baker's home. And you've already said that January 19, 2001 was 9,000 days ago. How do you know what the traffic was like, Detective Ricketts?
The route that we're going to their house, I drive a good bit, but I'll just say you're going to do it in an hour. During that time frame, someone from Athens, Clark County, I'm not sure who did that drive, it's going to take you approximately that amount of time. Now, again, not defending Chris, I'm explaining to you how investigations in those early 72 hours are done with trying to line up those statements.
Copy of this redacted. Okay. Court's indulgence. And I just want to make sure I understand your testimony. Your testimony is it takes an hour to get from Mr. Melton's parents' home to Miss Baker's home?
Yes, with traffic, I'm saying yes.
Well, hold on. Let's be clear.
So when I Google mapped it just a minute ago for you on the record, it said 1 hour and 4 minutes to do that 40 miles. So that was at 9:30, 10 o'clock in the morning past rush hour.
But you would agree in 2001, Athens wasn't the city it is now, right?
Judge, I would ask, Detective Ricketts was in the middle of an answer. Mr. Cruz cut him off with his next question. I'd ask that Detective Ricketts be able to finish his response.
We're going to allow him to finish his response, and then you may question.
Sure.
If there's anything you wanted to add, you may.
No, I was just going off the recollection of what I pulled up at 10:30 in the morning on Google for right now. And yes, I'm sure traffic was different in 2001.
Well, let's talk about this. It's 10:30. If, and we've already discussed this, if the person seen running committed this crime, he would have been traveling before 7:45. Is that fair?
Okay, yes, sir.
Okay. And he could have been traveling, we don't know, at 6:45 a.m. Is that right?
I don't know.
Okay. But you do know, as you just told this jury, that at 10:30 on February 10th, 2026, it's an hour and 4 minute drive.
Yes, sir, only because you asked me to look it up.
Sure.
That's the only reason I know
But
that.
that's irrelevant to our conversation about January 19th, 2001. Is that fair to say?
Okay.
Is that fair to say? Would you agree?
Yes, sir. That'll be fine.
Now, We have a discrepancy in the alibis, right? We have Josh saying Chick-fil-A. We have Mr. Melton not saying Chick-fil-A. Is that fair?
Yes, sir. They're both saying that. One saying Chick-fil-A, one saying that.
Okay. One saying what?
One saying Chick-fil-A and one saying the Wachovia Bank.
So you're saying the bank and Wachovia are next to each other?
They're close.
So how do we explain Josh saying Chick-fil-A before 8 a.m. and Chris saying Chick-fil-A after 9 a.m.?
Say that again.
Sure. Your testimony was that the Wachovia is right next to the bank. Is that fair?
Yes, they're close together.
And you just made the statement that Josh said Chick-fil-A, Chris said bank. Is that fair?
Yes,
Okay. Josh said Chick-fil-A before 8 a.m. Is that correct?
he did.
Okay. Chris says bank after 9 a.m. Is that correct?
Yes.
Okay. So that's a discrepancy. Is that fair?
Or both things could be true. They could have gone by that Chick-fil-A and then gone back to the bank. The bank doesn't open till 9.
So my question is this: why are you defending Chris Melton?
I'm not. You're asking for information, and I'm trying to give it to you from the 72 hours that we were working the very first. Now, in this, from the 19th, 20th, and 21st, not even working this case, I believe we did 20-some odd. I did 20-some odd interviews during that time. Typically, this is what happens during those first 72 hours, is just trying to get timelines. And then over time, you start pulling those timelines together.
Do you know if Mr. Faust got that courtesy?
I don't work here anymore, sir, so I don't.
But we can agree that Chris Melton got that courtesy.
I don't think Chris Melton got the courtesy. I think we worked the case.
Well, officer, we just talked about this. You said that you explained that the reason Josh said Chick-fil-A and Chris said the bank, you said two things could be true at once. You were saying they could have went, and this is your testimony, they could have went to, I guess, to Chick-fil-A by the bank first, and then after 9 a.m. went back to the bank. That was your testimony. Is that right?
Yeah, when we're looking at this during this time frame, so when you take somebody who's been involved in a crime or whatever else, and they've been a victim of a crime, and they're giving witness statements, things are recalled the next day or so. He forgot Wachovia, which is a timestamp thing. Don't know why he forgot that until Sunday. Don't know. Normal people, through the course of doing investigations for almost 35 years, do not walk through and timestamp their day. They can give you approximates and say this and that. The majority of people I've interviewed for homicides, whatever else, and not saying at the bank I was at 9:08, whatever else. Now, I understand what you're saying. This was a timeline in 3 days where we're trying to put people where they're supposed to be, and I'm testifying to those 3 days of what I did on those. And some of it, like I've told you, I didn't do those interviews, so I cannot answer that for you.
Sure.
We're trying to put people in those spots and then see what evidence moves from there.
You would agree that Ms. Baker is the victim in this case?
100%.
Since January 19, 2001, Ms. Baker was the victim. Is that correct?
100%.
And her family were victims. Is that correct?
100%.
And ACCPD's job as law enforcement officers are to make sure the victims are taken care of. Is that right?
Yes.
And to solve those crimes, correct?
Yes.
And when questions pop up as a law enforcement officer, your job is to answer those questions. Is that right?
Yes, sir.
Your job is not to explain away those questions. Would you agree?
I'm not. I'm explaining away 72 hours.
I'm not saying my specific question is your job is not to explain away those questions. I'm not speaking.
I'm sorry. I took it as you were implying, but no, it's not. I agree with you.
Now, on January 20th, 2001, you spoke with Mr. Bill Teeter. Is that correct?
Yes, sir, over the phone.
And Bill Teeter is the gentleman that worked at Truck Customs.
Yes, sir.
Okay. You had no reason to believe whatsoever that Mr. Teeter and Mr. Melton were personal friends.
At that time, no. On the 21st, no.
Okay. And based on your interaction with Mr. Teeter, you understand that Chris Melton's relationship with Mr. Teeter was solely as a customer.
At that time, yes, sir.
And you would agree that gives Mr. Teeter a certain type of credibility, right?
Yes.
He would have no reason to lie for Chris Melton. Is that fair?
Yes.
Okay. He would have no reason to try to cover up for Chris Melton. Is that fair?
That's correct.
Okay. And Mr. Teeter told you that Chris came to his shop around 10 a.m. Is that right?
Yes, sir. I believe that's correct.
Cross here. Put Teeter in that box. So we could say that Chris's trip to Truck Customs was confirmed. Is that fair?
Yes, sir. He said Chris had to come by there once in the morning around 10 a.m. The only appointment Chris had that day was for 4 o'clock. The initial appointment in the morning, the reason he said, if
10 a.m.
on the tape,
10 a.m.
is it was just a show up for a measurement, and that was a stop-in. They measure the compartment or whatever else, and then they go, and then would come back for that appointment later in the day.
Okay.
But the appointment was for 4 o'clock.
So we've confirmed around 10 a.m., correct? But we still have not confirmed that window between 7 a.m. and 9 a.m. Is that fair?
Yes, sir.
So based on what Mr. Teeter told you, it is fair to say when Chris Melton told you that he went to Truck Customs at 9:30 or earlier, that was not true. Is that correct?
His timeline was off on that one because Truck Customs, if he'd have left the Wachovia to go there, he would have been there right around 10.
Detective, if you can answer this question.
Sure.
Do you feel the need to explain for Chris Melton?
Again, you're asking about a timeline,
Sure.
and I'm trying to explain to you from where that Wachovia was to Truck Customs is not a very far.
Well, this was my question. My question was, and I'll ask it a different way. Chris said he was at Truck Customs from 9:30 or earlier. Do you agree?
That's what he said, yes, sir.
Okay. Bill Teeter said that he was at Truck Customs around 10 a.m.
It's correct.
Okay. And you would agree this is significant because once you told Chris Melton that you talked to Bill Teeter, he changed the time that he was at Truck Customs to 11 to 12:30 a.m. Is that fair to say?
The second interview is when he mentioned that he went to Wachovia.
Officer, we're talking about Truck Customs.
Yes.
Okay.
So, and that's why I believe his timeline just slid just a little bit, but that was a timeline from 9:30 to 10:30.
Did Mr. Faust get the same courtesy from law enforcement to explain any discrepancies he may have had?
Judge, I'm going to object to the form of the question as being argumentative as well as lack of personal knowledge. As Detective Ricketts has already said, he never worked the case at the point that Mr. Faust entered it.
I will withdraw the question, Your Honor.
I'm going to sustain that objection.
Yes, ma'am. But after you told Mr. Melton that you talked to Mr. Teeter, Chris Melton then changed his time to somewhere between 11 a.m. and 12:30 a.m. Is that correct?
I don't know if I told Chris that I talked to Bill or not. I cannot testify to that. Chris told us about that, though, the evening he came in and brought up Wachovia, which in a normal investigation, somebody bringing something else up they did that day is not that far out of the realm of possibility.
Okay. So this is possibility here. You say this would be normal for Mr. Melton?
Yes, sir.
Okay. On the morning that Miss Tara Baker was killed, this is normal?
What do you mean by normal?
Sure. You said this is not outside the realm of possibility.
I'm talking generalized in an investigation when somebody comes back in with a time. Like I said before, people don't roll through the day now pretty much with timestamping, especially in 2001. With phones and everything we have now, you can timestamp pretty stinking well. I'm just saying that's along the realm of that kind of ballpark window that we're looking for just to keep things for that initial 72 hours.
Well, I would like to talk about police. Police, they live in timestamps. Is that correct?
Yes, sir.
Okay, police, they confirm. If you say you went somewhere, a police officer's job is to confirm it, correct?
That's correct.
Because you got to give answers to the community. Is that fair?
Yes, sir.
And you have to give answers to the family. Is that right?
That's correct.
And if the family asks you, where was Chris Melton at 8 a.m., an appropriate answer isn't, well, in the general realm of possibilities, he could have been anywhere between these places. Is that fair to say?
I understand what you're saying, and yes, that is fair to say. And in that first 72 hours, we're putting in on the timestamps of what's happening in that first 72 hours.
Yes, sir. Would you have any reason to disagree with me in the multiple interviews you conducted with Chris Melton? He has never stated that he went to Chick-fil-A.
No, sir, he is not to me. And again, he may have to some other investigators after that, but not to me.
Sure. And we've already agreed that you never personally confirmed that Josh went to Chick-fil-A, right? That's unconfirmed.
By me, yes, sir.
And we've agreed that you talked to Chris the second time on January 21st, 2001. Is that right? Now, his parents were present. Well, his father was present at the interview. Is that fair?
Yes, they drove him there. But at the interview, I believe it's just Detective Newton and myself.
Now, during your interview with Josh, Josh told you that he had worked with Chris for a year. Do you recall Josh making that statement?
Yes, sir.
However, Chris told you that he had only met Josh in December of 2020. Is that fair? I'm sorry, December of 2000. Please forgive me.
I understand that. Done that a lot lately. I don't know. Is that in my notes?
It's in the recording.
That's a good possibility. Then I won't argue that with you.
So, December 2000 was just a month from Miss Baker's death. Is that fair to say?
Yes, sir.
Okay. And if you can, write Chris 1 month, Josh 1 year. And this is a very important area for us, officer, because I do think you did. I think you did the best you could with the facts that you were given under the circumstances. So I do want to say that, and I do appreciate your service tremendously. Okay.
Okay.
But I do want to ask you about the interview on January 21st, 2001, in regards to Chris's statement about going to Wachovia Bank. Okay.
Okay.
Now, he told you that he was in the bank on Friday, January 19th for 35 minutes. Is that correct? And that would be on the recorded interview if you don't
He
see
said he's in the bank for around 30 minutes. That's just what I typed in my notes.
Would you have any reason to disagree that he specifically said 35 minutes?
I put 30 in my notes, but 35 won't be a...
Would you like to hear the audio recording?
No, sir, I'm fine.
And if that's true, that Chris Melton spent 35 minutes in the bank on Friday, January 19th, you would agree that it's not an insignificant amount of time to spend in the bank. Is that right?
No, sir.
Okay. However, Josh never mentions going to the bank for 35 minutes with Chris, does he?
He does not.
In fact, he never mentions the bank at all. Is that right?
He does not.
Now, we've agreed that Chris' father was with him on the January 19th and January 21st interview. Is that fair?
Yes, sir. I don't believe he sat in on the 21st. He did sit in on the 19th.
Okay, so we'll discuss the 19th. Chris's father never agreed with the statement that Chris left his home between 7 a.m. and 8 a.m. on January 19th while he was present in an interview with you.
No, sir, not in that interview.
And during the weekend of January 19th, 2001, you did not speak with Mr. Melton's mother. Is that correct?
I did not.
Now, Dad knows that Tara has passed away, Mr. Melton's dad. Is that right?
Correct.
Okay. Dad knows that Mr. Melton's son has conducted an interview with law enforcement. Is that fair to say?
That's correct.
But Mom never calls you, Mr. Melton's mom, she never calls you and says, hey, Detective Ricketts, Chris was here with me that morning of Tara's death. Is that right?
No, sir, I did not do that.
Chris's parents don't reach out to law enforcement at all. Is that correct?
Except for coming to the police department twice voluntarily.
With Chris. Is that right? Only Josh and Chris are the only two people that stated that they left Chris Melton's parents' home around 7:15 a.m. Is that correct?
Yes, sir.
And as of January 21st, 2001, with your involvement in the investigation, besides Josh, there were no other witnesses or documents confirming where Mr. Melton was between 7 a.m. and 9 a.m. on January 19, 2001.
Past the 21st, I cannot answer that, but from the 21st backwards, that's correct.
And I believe you mentioned this on direct. You told Chris that Tara was probably sexually assaulted. Do you recall telling Chris that?
I did.
Okay. And when you told Chris that, he didn't start crying, did he?
No, sir.
Okay. Chris didn't become upset, did he?
No, sir.
Chris didn't say, I need a moment to myself. Is that fair?
No, numerous times during the interview he stopped, but no, sir, he did not.
Okay. And Chris didn't say, I hope you find who did this before I do. Is that correct?
Not on the 19th. Mentioned it on the 21st while we were at the jail at the jail at the phlebotomist, getting blood work done there. Just a statement he made in the hallway, but yes, sir, not during an interview or anything of that nature.
Can you show us that statement in your
It's
notes?
not in there, sir.
Okay. And we've already agreed that January 19th was over 9,000 days ago.
100%.
But Chris did ask you about the evidence in the case. Is that fair to say? and specifically Detective Ricketts. Chris asked, in response to you telling Chris that Tara was sexually assaulted, did you find some stuff on her like semen? Do you recall Chris asking that question in response to you telling him that Miss Baker had been sexually assaulted?
Yes, sir.
Did you find that odd that his response was about asking questions about the evidence?
No, for a couple reasons of sexual assault, and that's one of the reasons John Newton and some of those folks were brought in for the sexual assault is if he's not sure she's been raped. Sometimes people wander down that road of how do you know that this person was sexually assaulted.
So can I ask you this before you finish? So it's normal to tell someone that's engaged or preparing to be engaged to another person that the love of their life has been sexually assaulted, and before they say anything.
Back to the form of the question as being argumentative, Judge, I'd also ask that the witness be allowed to finish the answer they were giving before they were interrupted by Mr. Cruz.
I think that is correct, actually. I'm going to sustain the objection. It is argumentative.
Yes, ma'am.
And if this witness chooses to finish his statement, he may. Otherwise, you may continue.
I withdraw the question.
Okay, yes, sir.
We've established that Chris Melton was in his vehicle on January 19, 2001. Is that correct?
At the police department?
No, the morning of January 19, 2001.
Yes, sir.
You would agree that you did not search Chris Melton's vehicle for the presence of Miss Baker's blood. Is that correct?
No, sir. From the 19th to the 21st, I did not.
Okay. Well, any other time past the 21st?
I did not. No, sir.
Would you agree that it's important to search a vehicle in a murder case? If it requires travel, let me add that. If the murder would require travel, you would agree that it's important to check the vehicle.
If you had a viable suspect at that time, then yes.
And Chris Melton was not a viable suspect at that time?
At that time, through everything we were getting was coming voluntarily, timeline was coming together. So at that time, by the 21st, he was not.
Well, what choice did he have, officer? Because you stated if he didn't agree to blood, you would have got a warrant.
Did not tell him that.
But it's true, right?
100% I would have. That was part of the interview when I started with him. At the very beginning of the tape, I make it very clear to Mr. Melton that he's there voluntarily and giving me a free and open statement. Because going into that interview, I don't know if he's a suspect or I don't know if he's a boyfriend of a victim. So as you start going down, that's what these 3 days are for, is to try to figure out what that person is and then what do I need to get to prosecute this.
Okay. So my question, my specific question to you, and if you can answer it with a yes or a no, he didn't have an option but to give blood. Is that right?
He did have an option, yes. At that time, he could have told me no.
And you would have got a search warrant and still got his blood?
We wouldn't have got blood that day, but I'd had to see a judge and move forward.
Okay.
Yes,
so you would have had his blood regardless?
yes, sir. But at that time, he was not told, hey, if you don't give this to me, I'm going to go get a warrant.
Sure, that's fair. And as far as coming to the police department voluntarily, were you the one that called the family and told them to come to Athens?
No. What do you mean by the family?
Sure, Miss Baker's family.
Oh, no, sir.
Okay, but you are aware that officers called them and told them to come to Athens. Is that correct?
I would 100% believe that, yes, sir.
Okay. But to your knowledge, no one called Chris and told Chris to come to Athens. Is that fair?
Well, Chris was paged by Miss Baker.
Law enforcement. We're talking about law enforcement.
Well, that's not the question he asked, Judge, and I think the witness is entitled to answer the question that he was asked.
You're going to allow him to answer.
Well, I withdraw the question, Your Honor. I withdraw that question. Did law enforcement call Chris Melton to come to Athens?
To my knowledge, no.
So he voluntarily went to Athens the day that he found out that his girlfriend was murdered?
Yes.
Okay. And you all asked Chris Melton to identify the body. Is that correct?
Lieutenant Durham, I believe, is the person that I can't testify to who asked him, but yes, he was asked to identify the body.
That's fair. And Chris Melton, you stated that he didn't appear with a lawyer. Is that right?
He did not.
Okay. If he appeared with a lawyer, that would have looked a bit suspicious to you?
It would have been way out of the norm.
Okay. So if Chris is trying to avoid looking suspicious, the best thing to do is to appear voluntarily. Is that correct?
I don't believe so.
Now, you talked about the injuries to Chris Melton's hands taken on January 21st, 2001.
Yes, sir.
Okay. And Chris told you that those injuries came from punching a wall.
Yes, sir.
Okay, and we would agree that that is drywall in that picture. Is that right?
It is.
Okay, and we would agree that injuries to Mr. Melton's hands look like scratches. Is that correct?
Looked like abrasions would be what I'd call them. Abrasions.
Okay. Help me, what's the difference between abrasions and scratches?
Abrasions is usually when you hit something and it slides, it's open. A scratch is usually a line or whatever else. An abrasion is usually wider open. So if you look at the picture, there's more of an abrasion, a hit, that kind of thing.
Sure. Your Honor, can we turn on the projector?
Can?
Is that an accurate depiction of Mr. Melton's hands?
Yes, sir.
So you say this is an abrasion from punching a wall on the inside of his thumb?
I don't have a pointer, but if you look over to the index finger, all right, hold on. The ring finger and the next finger over it, that's what I'm calling abrasions right there. There's some other stuff on there that are nicks, scratches, things of that nature, but that's what I mean by abrasions, just that larger hit of something of that nature.
And this is my follow-up question. Did you confirm that Mr. Melton, well, let me say this. Mr. Melton told you on the 21st that he punched the wall. Is that right?
That's correct.
You all didn't take pictures of the wall until 2 days later. Is that correct?
I believe it's the 23rd when I went over there.
Correct. Did you confirm with anyone else that Chris Melton punched the wall and that's where those injuries came from?
I did not, but I believe somebody talked to his roommate in one of the reports.
Well, he stated that his roommate wasn't present when it occurred, officer.
The only other person that would have been in the house is just the two of them then.
So you don't know if they talked to the roommate, is what you're saying?
No, I'm saying somebody else did, but I did not talk to that roommate.
Now, on January 23rd and 24th, 2001, you obtained a hair sample from Chris Melton. Is that correct?
Yes, sir. I believe that's correct.
And this was done with Detective Newton?
Yes, sir.
Do you recall requesting and obtaining a court order for phone number 678-725-4136?
I believe that was the 24th that I did the hair samples. Is that correct? Before I said yes, but I want to make sure I'm on the same page with
That
it.
is correct. I have the 23rd and 24th.
Okay, the 24th. I have the 23rd, 24th written in there, but I just want to make sure that's the date you're talking about.
That is
The
fair.
report you're looking at.
No, sir, just my notes.
Okay. Yes, sir. We did do hair samples on those days.
Okay. And you also obtained a court order for phone number 678-725-4136. Is that correct?
If I signed for it, then yes, sir, I did. I don't have a signed copy of that with me.
Would you like to see it?
Yes, sir.
Your Honor, after this, can we take a break just in case the jurors need to use the bathroom?
And just let you keep going, Mr. Cruz.
Can you put those in order for me, please? With the stickers should be on the front page. Thank you. All right, is it okay if I approach you and show you the court order?
Yes, sir, please.
You're welcome.
Yes, that's my signature.
Okay. And that number was for, excuse me, you recognize that document, you recognize that court order?
I do recognize the court order and my signature. Yes, sir.
Okay. And the 678-725-4136 number belonged to Mr. Melton's cell phone. Is that correct?
From my recollection, I believe so. I can look back at my notes, but I think that's what he gave me.
And I believe it's listed in the court order itself, officer.
Yes, sir, but I want to make sure that's the same number he gave me at the interview. Is that
Understood.
understand what I'm saying?
I do.
Hang on one second. But I believe you're correct. You okay? I believe that's his next tell, yes, sir.
Okay, excellent. I'm waiting on the state to review some documents I gave them. May I approach you?
Yes, sir.
The document? Thank you.
Judge, can we approach about this briefly?
Do you recall the records that you received in response to the court order?
I do not recall them.
Would seeing them refresh your recollection?
It might.
May I approach you?
Yes, sir. It looks like what we used to get faxed to us when we put these things in.
Do you recognize those particular records?
I'll take your word for them. The document you showed me a minute ago was my signature for the request.
So I'd like to talk about those records, okay?
Okay.
And Your Honor, I am not tendering the records into evidence, but I would like to mark them for the purpose of the records. Is that okay?
I'm going to object, Your Honor. The witness has indicated that he doesn't have necessarily a direct memory of these records, but more importantly, as we discussed at the bench, they're not admissible in the manner that Mr. Cruz is trying to admit them at this time, and therefore they can't be testified to as far as contents from them in front of the jury.
That is correct. I'm going to sustain that objection.
Yes, ma'am.
Hey, thank you.
On January 21st, 2001, you spoke with a young lady by the name of Miss Laura Sherling. And that's your January 22nd, 2001 report. And it's page 104, first paragraph, first sentence.
Okay, I don't have the 104 numbers. I just have some of my case reports. What was the name again you gave, sir?
Lauren Sherling.
Yes, sir.
Okay, and that interview with Miss Sherling was recorded, is that correct?
Yes, sir.
Okay, and Miss Sherling is a former co-worker of Miss Baker?
Yes, sir.
All right. I have no other questions for you. I want to thank you so much for your patience and your time and your service to this nation. Thank you.
Okay, thank you very much, sir.
Any redirect, Mr. Yalamanchili?
I do, Judge. Mr. Ricketts, I want to go back and talk to you about some answers that you started during cross-examination before being cut off. Mr. Cruz asked you a series of questions about whether you recall certain sporting events that occurred back in 2001, the Super Bowl, the World Series, things like that. And then you began to give an answer that talked about the differences between this horrific crime and those sporting events in your mind and your ability to recall certain facts.
Yes, sir.
How is it that the murder of Miss Baker is different than the Super Bowl or the World Series from 2000 and 2001 to you?
From the fall of 2000 to 2001, unfortunately, I worked numerous homicides and then a serial rape case, and in this case, those incidents leave a lasting impression, if that makes sense. So it's not something that you forget. Now, when you read over your reports and records, you remember it. Those small things come back, the details come back. When you start reading back through your reports, it opens up stuff, if that makes sense.
Yes, sir, it does. There was another question where you started to give an answer and Mr. Cruz cut you off and then withdrew his question. It had to do with you beginning to talk about what you would have done if you had noticed a bunch of things or a thick coating on Mr. Melton's hands. Do you mind telling the jury what you would have done?
Objection. That was drawn out on direct examination, not cross-examination. Mr. Yalamanchili asked him what he would have done if he saw items on his hand when he was fingerprinted. So I would ask, I would object to that question. That was nothing that came up on cross as far as what he would have done. That was direct examination.
Okay, what is your specific objection, though, Mr. Cruz? Mischaracterization, perhaps?
Characterization and relevance. It doesn't follow the line of cross-examination.
All right. Mr. Yalamanchili, you care to respond to the objection?
Yes, Your Honor. I've got it in my notes underneath Mr. Cruz's cross. Obviously, the court will recall that in whatever way the court recalls it. But Detective Ricketts was in the process of explaining what he would have done if it were some kind of thick coating, and then Mr. Cruz stopped him in his answer.
Right, I'm going to allow it. You may continue.
All right. So, Detective Ricketts, I'm going to kind of ask you that question again. During cross-examination, Mr. Cruz stopped you in the middle of your answer as you were discussing what you would have done had you found a thick coating of things on Mr. Melton's hands. Can you explain to the jury what you would have done if you had seen that?
I'm going to overrule the objection. You may continue.
Well, number one, if it's a large amount, you can't be fingerprinted. So that would have interfered with just the fingerprinting if there was a large amount. Now, on the back of the hands or whatever else, there wasn't enough stuff on his hands to cover up anything that might have been there. You could easily see it. So if there would have been things that we would have had to take pictures, and then we'd have had to move with Lieutenant Durham and some other ways that we would have gone on from that moment on. But those were not noticed. And again, I'm literally holding his hand while I fingerprint him. I mean, my hands are holding finger by finger as I flip that hand over. I'm having to hold his hand.
Also, during your testimony, after the distance from 160 Fawn Drive to Mr. Melton's parents' residence was established, you testified to a timing run that was done by ACCPD at the time. Is that correct?
Yes, sir.
And I just want to clarify that because I feel like it might have gotten lost in your testimony and questions coming in while you were talking.
Objection, Your Honor. This calls for hearsay. We explicitly did not ask him about the time stamp. We disagree with the time stamp that was given. But the reason we didn't ask that is because we know under the law that is hearsay.
All right. Any response to the objection?
Well, Judge, this is a response that was given to Mr. Cruz's question about what was done. The response is about what ACCPD did at the time. And the answer was given during Mr. Cruz's cross-examination. I'm just going back to talk about that answer. That answer wasn't objected to or asked to be struck or otherwise identified as hearsay by Mr. Cruz at the time. So it's in evidence, and I think it's an appropriate grounds for redirect examination.
All right. Yes, sir.
I would just ask, Your Honor, I'll leave it to the discretion of the Honorable Court, but if that door is open, the reason I didn't go down the impeachment route with that line of question is because I wanted to follow the law. That isn't appropriate to bring out of a witness. That was non-responsive to my question. But if the state is allowed to go down that line of question, I would just ask the Honorable Court allow us to follow up with that line as well on recross examination.
Okay. Thank you, sir. The objection was with regard to hearsay. I don't find that this question is going to elicit hearsay. I'm going to allow you to ask it. Certainly on any recross, we will address any issue that the state might object to, and we'll take it up again if we need to, but you may go ahead.
All right. And so, Detective Ricketts, what was it that you stated was the time period when ACCPD or law enforcement did a test run back in 2001?
It was over an hour with traffic. So it took them just a little bit over an hour to make that drive.
Okay. I want to talk to you just really briefly about your familiarity with some of these areas in Loganville, Grayson, Truck Customs. During your testimony, you made reference to the fact that you drive that route at least semi-frequently. I'm not asking you an address where you live, but in general terms, what area of the state of Georgia do you live in?
Toward Gwinnett County, that way off 78.
Are you familiar with these areas that we've been discussing, kind of independent of your investigation?
Objection. Gwinnett County to Athens is irrelevant to any facts that are already in evidence in this case.
All right. There's a relevance objection. Mr. Youngman-Chili.
So is the objection to the follow-up question that I asked or the answer that Mr. Ricketts gave to the previous question? I'm just not sure.
Here, go ahead.
To the follow-up question, Your Honor.
All right. Do you want to respond?
Yes, I do, Judge. The follow-up question was, are you familiar with the areas that we've been discussing as it relates to Loganville, Truck Customs, and Grayson. So I think that is relevant.
Okay. Is that your objection, Mr. Cruz?
The follow-up question, Your Honor. The follow-up, he asked him about Gwinnett County to these parts around here, Your Honor. That is not relevant. Mr. Melton stayed in Loganville, which is outside of Gwinnett County. So Gwinnett County to Athens is irrelevant in this case.
Okay. Let me just say this. I think you're referring to the question before the follow-up question, but we can talk about that. I think that is your objection. All right. And so that question has already been asked and answered, but let's let the state, if they choose to, respond to the objection about relevance when you asked about the Gwinnett County area. Do you care to respond?
Yes, Judge. I think Detective Ricketts, during cross-examination, indicated he was familiar with that general route. And now I'm going back to establish why it is that Detective Ricketts is familiar with that general route. And then, obviously, court heard the follow-up question, which had nothing to do with Gwinnett County. It had to do with his familiarity with these specific areas that we've been discussing.
All right. I'm going to overrule the objection. You may continue.
So, Detective Ricketts, I'll go back. I'll ask that question again. So, as it relates to the discussions we've had about Loganville, Truck Customs, and Grayson, are you familiar with those areas?
Yes, sir. It's like a small triangle there. We're there together. Loganville, Grayson, all those little areas are very close to each other, like in a triangle.
And so when you say very close, let's just talk about Loganville and Grayson. How close are we talking about?
5 miles or so. I mean, they almost touch each other, I would say.
Okay. Repeatedly during cross-examination, Mr. Cruz made reference to you being unable to obtain documents from Nash Plumbing and some of these other locations that both Mr. Melton and Mr. McCurdy said that they both went to. I just want to clarify, because I think sometimes unable can leave a certain impression. Did you ever actually even attempt to do that?
I did not.
Okay. So is it fair to say that you didn't ask and then someone wasn't able to produce them? It's just that you yourself never asked.
That's correct.
Okay. Also want to talk a little bit about differences in timelines. And obviously, Mr. Cruz had Mr. Hill write some things on the flip chart. I don't need the flip chart. Detective Ricketts, in your having received all that information from Mr. Melton, Mr. McCurdy, and Mr. Teeter about Mr. Melton and Mr. McCurdy's whereabouts on January 19th of 2001, was there anything that you received from those individuals that caused you concern about the integrity of those statements regarding where they were?
No, similar to the whiteboard, we use a similar thing, except we go across. And on any kind of investigation we started back when I did those, and even to this day, we would go across with a timeline, and you get the second subject, and you go across with a timeline, and you get the third and the fourth and the fifth, and you start looking for consistencies and inconsistencies in those timelines. In this first 72 hours, just because Chris came back and remembered the bank, again, like I said when Mr. Cruz was talking to me, that's not abnormal for the timelines not to be minute by minute, to be some overlap. So on that first 72 hours, we weren't concerned about that overlap. We weren't concerned about any of that. We wanted to move on toward getting fingerprints, DNA, and push the investigation that way. So we were trying to secure all that, but that timeline didn't give me any pause at the beginning. Now, we've had investigations before, just to give you a this or that, investigations where as soon as you put the timelines on, you're like, they're in another world. So when they're close together and you can put that line close together on a board, you can kind of work that out. And I wasn't, in that first 72 hours, I was not at all uncomfortable in what we were doing.
And so as far as these variations that you saw and that we've talked about between Mr. Melton, Mr. McCurdy, and Mr. Teeter, would those be consistent with variations that you had experienced in other investigations that you had?
Yes.
Okay. Was there anything unusual to you about those things not being minute for minute exactly the same?
In the first 72 hours plus, no. In that first 72, 96 hours, nothing was out of that realm of that I was concerned about, that I needed to move on quicker, if that makes sense.
Right. And so I'm going to ask you, Mr. Cruz asked you about things that Mr. Melton's father may have said or not said to law enforcement. Was there another law enforcement officer who followed up with Mr. Melton's father?
In my recollection, yes. Lieutenant Durham was sectioning out what needed to be done. Again, as for this case, on that weekend, that Friday, Saturday, I was scheduled to be back going to school on Monday, leaving the state. Canceled that trip because of Friday. This was way more important. But Lieutenant Durham was assigning people to do those tasks, to do those follow-ups. So yes, sir, somebody was assigned to do that follow-up and talk to that person.
Do you believe, one second. Do you believe that seeing a police report from Rebecca at the time Taft would help refresh your recollection?
Yes.
Objection. Relevance. Improperly attempting to refresh a witness's recollection are my two objections. So relevance and improper attempt to refresh recollection. Those are my two objections.
Okay. I'm not sure I know what you're trying to refresh. You didn't finish the question. So he's made two objections.
So first, as to the relevance factor, this would be information that Mr. Cruz solicited on cross-examination about statements made by Mr. Melton's father to law enforcement regarding Mr. Melton's whereabouts. So that's one. Relevance. It is absolutely relevant, even independent of Mr. Cruz's questions on cross-examination, but certainly at the point that the information is solicited on cross-examination, it would be relevant in a redirect. Improperly refreshing the witness's recollection, what the law says about that is that a witness's recollection can be refreshed with anything, including, things that might not make sense. I could hand him a pack of exhibit stickers and ask him if it refreshes his recollection, and it may or may not. So I don't think that that's a valid legal objection in this circumstance.
Yes, sir.
I have one. Double hearsay. Double hearsay. It's a report from one person that he's going to show the detective to ask, or I guess refresh his recollection as to what a third person said. So I'll add that objection as well, Your Honor.
Well, and Your Honor, if I may respond to the new objection. So once Mr. Cruz solicits that information on cross-examination, I believe he's barred from raising an objection during the redirect examination as to that same information.
Yes. One more time. Yes, sir.
I know Your Honor knows the law. I'll just leave it there.
Okay. Thank you, Mr. Cruz. All right. With regard to the relevance, I certainly find Mr. Cruz, I'll just speak to both of you since you all have talked about getting together over the break. Anything that the court needs to discuss with regard to any evidence that you all were discussing?
I don't believe so at this time, Your Honor. I don't think I'm going to necessarily have any disagreement with I guess, the substantive portions of what Mr. Cruz has indicated that he believes should be redacted. Okay. They seem on first review to match up with the things that the state noted as well. Okay. We talked before Your Honor entered the courtroom, and there may be like a sentence on each side of the timestamps that one party or the other seeks to admit. But I think we have the same understanding about the information that would not be admissible in front of the jury. And so I don't think that we need the court to make any rulings at this time.
Mr. Cruz?
I would ask that the motion is granted.
Right. I am going to grant your motion, but I want to make sure I've got the right language. But go ahead. Yeah.
But we are on the same page. As Mr. Yalomachili stated, we're on the same page with the timestamps.
Okay.
I'm assuming, and I asked Mr. Yalomachili, is this Mr. Howell we're going to get this in, or Ms. Bigham?
I intend to play it through Agent Howell. Okay. And so when we do that, I mean, the one thing that I would say is just out of an abundance of caution, a little additional time to make sure that I have the mechanism of making sure it's not published to the jury down in a way where it doesn't cause some kind of issue. But we can kind of cross that bridge when we get to it.
Okay.
And I think, we can push forward. It's 2:30 now. I tell you, the state intends to call Agent Bigham next.
Okay.
So I imagine Mr. Cruz would have a fairly lengthy cross-examination for, just based on some of the prior hearings and stuff. So if that doesn't get us to a latter part of the afternoon, we could call Agent Howell, who has some testimony about crime scene and other related things. But I would ask the court that before I got to the point of talking to him about the statement and putting it into evidence, if we could break for the day at that point, just so, or just not start him, honestly, might be. But however the court wants to handle it, we'll take your direction. But I will say a little more time to make sure I have the redactions exactly right will be helpful.
All right, thank you. Yes, sir.
I'm just asked out of abundance of caution, and Mr. Yalomachili may already be about to do this. But if not, our office could cut off the video. We actually take parts out of the video, if you all would like, and give a copy of the video that would play through, but only with the relevant portions.
I'll let y'all work on that. I don't think I need to get involved. I don't think I need to get involved in that. I'll let you all talk about it. I think it is fair to say that we do need to take a break before you wanted to introduce the video. We'll do that whether it's the end of the day or tomorrow morning. Just for the record, to be clear, the motion is granted. It has always been granted. I think the issue was to get both parties on the same page if possible, and then if not, I'd hear both arguments about what is admissible and what's not. But as long as both of you have agreed that the portions that are going to, as long as you both have agreed to the portions that are going to be redacted, I'm not going to get involved in all of that. That's fine. I will grant your motion with the basically stipulated moment that you both have come to about what needs to not be entered into evidence. So if we need to take anything up, if it becomes clear that maybe you don't have a meeting of the minds, you need to let me know as soon as possible so that we don't, the jury doesn't hear it. But other than that.
Yes, Judge.
All right.
That's the plan. I think so. Thursday at the latest. Today's Tuesday.
I will. Yeah.
Thursday at the latest, but I would anticipate
Field has asked to remind you, if you can, to wear the lanyard as best you can, or use the microphone so she can hear you.
Yes, ma'am.
Thank you very much. And if Mr. Yalomachili has that issue, we're going to find one for you too. So.
Yes, ma'am.
She just needs to hear you, that's all.
Yes, ma'am.
All right. Anything else, Mr. Cruz?
I know the Honorable Court talked about this morning in regards to the link. One of the witnesses, they're out of the country, so I just want to make sure that I can sync it up with them before the state rests. And I understand the state may be resting at earliest tomorrow, at latest Thursday morning.
Oh, you mean for the WebEx?
Correct.
Sure. So when you all seem to have a better idea of when that person needs to be called, we'll take it up and we will figure out the best time. If this person is out of the country, we're also, I guess, dealing with a time change.
Right.
So we'll work it out. We'll make it happen. It's not terribly complicated, but it does require some advance preparation to be able to make it happen.
Yes, ma'am. And just to let the court know, I would have to give her advance notice because I think when we're here and it's daytime, for her, I think
Right. I mean, that's what I mean. Yes, I understand that completely, but I think it's just best to get a little bit better time frame.
Yes, ma'am.
Because if you give a time frame now and that's not going to be the time frame, it's hard to change it. You'd have to sort of cancel it and do it all over again, and that might be more complicated. So, but we'll make it happen. I think the one thing to tell all your witnesses, whoever is going to be on WebEx, and I don't think the state has made a proffer that any of theirs are going to be on WebEx. Obviously, it's the defense's ability to object to that. But WebEx is the medium, and so, or the mode, or I don't, whatever you call it. And so your witness is going to have that downloaded on whatever apparatus your witness is going to use, whether it's a phone or a computer. WebEx is the only medium the courthouse can use.
Yes,
so, all right. Anything else, sir, before we bring jury up?
No, ma'am.
All right, thank you. Mr. Yellow-Mitchell, Ms. Rowland, anything else?
No, Judge.
All right, thank you. Mr. Chair, if you'll bring the jury out, thank you. On the record, State of Georgia versus Edrick Faust, SU 24 CR 0547. State ready to proceed?
State's ready, Judge.
Defense ready?
Yes, ma'am.
All right, thank you. Mr. Yellow-Mitchell, you may call your next witness.
State calls Agent Elizabeth Bigham.
Your Honor, before you decide, can I just move this?
Yes, absolutely.
Your Honor, we need to take up a matter outside the jury if Ms. Bigham is being called before she testifies.
All right. Ladies and gentlemen, I know you just got here. I'm going to take up something outside your presence I was not aware of. If you'll have a seat and don't discuss the case. We had done this before the jury came out, Mr. Cruz, but go ahead.
And I apologize, Your Honor. I was under the belief that Jeremy Howell was going to testify, and that's why I didn't bring it up. I was going to wait till Ms. Bigham testify before I brought it up. But we're going to get into, with Ms. Bigham, her case file and the case file. As the Honorable Court is aware, during a prior hearing, Ms. Bigham testified that she's seen every document in this case. One of the documents that we're going to discuss with Ms. Bigham includes where Mr. Faust was staying at the time of, or at least the weekend of, Ms. Baker's death. I would ask the Honorable Court, because the only thing we're going to get into is just the address and where he was staying. However, it goes into a matter that the state has expressed that they don't intend to introduce in this case. And I would like the Honorable Court to provide an instruction to Ms. Bigham not to delve into the incident or the specifics of the incident involving Mr. Faust and Mr. Christian Foster. And we will not open that door by asking specific questions about the situation with Mr. Faust and Mr. Foster. We only intend to discuss Mr. Faust's address on the weekend of Ms. Baker, and before Ms. Baker's death.
All right, so it's motion in limine.
Yes, ma'am.
All right, any response to the motion?
I guess I would like to know what the document is first that Mr. Cruz is making reference to.
Didn't we also already have a motion in limine with regard to Mr. Foster?
We did not have a hearing on this. The state stated that they did not intend to call Mr. Foster.
Okay, so we've had a discussion. Okay.
Picture. I don't want it to fall on. Pictures though. It looks like it's about to fall.
Your Honor, it appears from a preliminary review of this document that what Mr. Cruz is referring to is a statement from one of the witnesses of the incident where Mr. Faust stabbed Mr. Foster, who states to law enforcement that she used to date the suspect for approximately a year. He lived with her for some of that time, and she additionally said that the suspect stays with his girlfriend, Brenda Howard, in Knollwood Apartments off of Old Hull Road. So, one, I don't think any of that is admissible. It is double hearsay. It is a statement by a witness to a separate law enforcement officer that is then memorialized in this report, and that'd be Detective Sean Potter, who I think is deceased, Judge. And so the state is not planning to elicit any statements regarding what was told to Detective Potter from Agent Bigham. And I don't believe that Mr. Cruz would be allowed to do so without it drawing a hearsay objection, which the state would make, and therefore I'm making an oral motion in limine to ask that Mr. Cruz not be allowed to elicit double hearsay information without the state having opened the door to the same.
Mr. Cruz?
Thank you, Your Honor. The statement is not hearsay. Ms. Bigham is the lead investigator. The state's position for this entire case has been that Mr. Faust stayed at 350 Cooper Road. As the lead investigator, the fact that Mr. Faust actually stayed in Knollwood Apartments goes to information that she knew, and that's the objective effect. As the lead detective, she was aware that Mr. Faust, or at least she had information in her case file, that Mr. Faust stayed at 350 Cooper Road. The state presented same in their opening, despite Ms. Bigham being in the courtroom with the state and having knowledge of this situation. So it's not hearsay. We're not offering it solely for the truth of the matter asserted. We're offering this information to show this is information that Ms. Bigham had. This is solely entered for its objective effect, so it is not hearsay. So, and the simple way is to, she knew this fact. She was aware of this fact. That's the sole purpose of it.
Okay, well, I guess let me start with this.
Sure.
First of all, that doesn't get around the hearsay problem, even offering it as something that tends to show an objective effect, or for the purpose of showing what's in a case file does not overcome a hearsay objection. So I want to get that straight. I guess what I don't understand is what are you trying to do with this piece of evidence? Maybe we should start with that. Are you trying to tender that or question Agent Bigham about what's in that document or something different?
So I would only, and I will follow the Honorable Court's ruling. I always have, I always will. I disagree with the interpretation of the law. I would like to provide the Honorable Court with some law in regards to non-hearsay, not hearsay, and hearsay. This will fall under, if I understand correctly, non-hearsay because it's offered solely for its subjective effect and knowledge that Agent Bigham knew. But as far as my intention with that evidence, it's just simply to ask her, same thing we've already discussed. You've reviewed the entire case file in this case. And based on your review of that case file, you're aware of information that Mr. Faust resided at Knollwood Apartments at least as far as the weekend of Miss Baker's death. That's as far as I would go with that line of questioning, Your Honor. And may I provide the Honorable Court with case law in regards to objective effect?
You may, but let me just ask the state what the question you have just made. Mr. Yalman-Shilley, based on that question that Mr. Cruz has proffered, I realize there are objections the state is making kind of surrounding what that question may elicit. But in terms of the question itself, does the state have an objection about that particular question?
Can I get the question one more time, Your Honor?
Mr. Cruz, if you don't mind proffering again for the court the question you said you were intending to ask.
Sure. So the first question would be, Ms. Bigham, you reviewed your entire case file. And based on your review of the case file, you are aware of information in your case file that Mr. Faust resided in Knollwood Apartments or at Knollwood Apartments around the time of Ms. Baker's death.
Okay. With regard to that question, Mr. Yalman-Shilley, I realize you may have some comments about, again, what you're saying the defense is trying to elicit. But in terms of the question itself, do you have an objection to the question?
I think that I do not have an objection to the question if it is phrased as you were aware that Mr. Faust lived at Knollwood Apartments.
Right.
I think once you make reference to information within the case file, you're getting to a point at which the question is referencing this hearsay information or double hearsay information that Mr. Cruz has just identified in this police report. I think he can ask Agent Bigham that question, and then she will answer it in whatever way she does.
I mean, I wanted to give you an opportunity to respond, but that would certainly be my sort of first response to you, Mr. Cruz, is that is not an objectionable question. I think the question becomes what happens with the answer. And so since we're talking about this document that you've just given to the state, can you proffer what might come next? Because we need to talk about whether the information in that document is going to be admissible.
Sure. Agent Bigham would be under oath, so I anticipate Agent Bigham, not even anticipate, I trust as an officer of the law she would be honest. So I couldn't imagine her saying no. The state would have obligation as well if Agent Bigham was to be dishonest under oath, and I don't even want to imagine that because I don't think that'll happen. But I expect that once I asked the question in regards to the information she had that Mr. Faust stayed in Knollwood Apartments around the time of Ms. Baker's death, I just anticipate that being a yes and us moving on.
Okay.
Well, and Judge, if I could briefly, just, I mean, anyway, I don't know what Agent Bigham's answer will be. I would like to state whatever her answer is. I don't agree that one answer or the other could be characterized as a dishonest answer when we're talking about the source of the information being a double hearsay statement from a witness that, from my memory out of the case file, the GBI never directly talked to in kind of a collateral matter involving Mr. Faust, or an other acts matter at the minimum.
Okay.
And I have a case for you, Your Honor.
Case for the court for what?
In regards to this information being non-hearsay.
All right. If you want to give me the case, but explain to the court why it is not hearsay. I mean, you've stated that it is, I'm assuming what you meant, but tell me if I'm wrong, that you're saying that it is not hearsay because it doesn't go to the truth of the matter asserted. Is that
Correct.
what you're saying?
It goes to notice.
All right. All right. Whatever you would like to provide the court, you certainly can.
It's a 2025 case. It's Vaughn v. Winfield, Homeowners Association, Inc., 375, Georgia Appeal, 913 Southeast 2nd, 74. And as an example in this case, it states, disclosure at the time of, and this is the facts of this specific case, but showing how it was non-hearsay. Disclosure at time of sale that homeowners association was mandatory was not hearsay offered for its truth, but offered to show buyers had notice of the legal status of the association. The next case is U.S. v. Schley. That's SCHLEI. That's 122, capital F, period 3D, 944. This is page 981. And it states, statement offered for the effect it would have on the hearer, providing knowledge that certain instruments were forgeries, is non-hearsay. Also, Benford, and this is the last case I give on record. I have a list of them, but this is the last two cases I give on record. Benford, BENFORD, v. Richards Medical Co., 792, capital F, period 2D, 1537, page 1540. Non-hearsay when it's shown or entered to establish the effect on the hearer. In that particular case, it was to prove notice of problems. In our case, it's to prove notice of Mr. Faust's address at the time of Miss Baker's, passing. And the final case is U.S. v. Darby. That's DARBY. That's 744, capital F, period 2D, 1508, page 1524. And non-hearsay when introduced to show effect on the hearer. In that case, to intimidate witnesses. In this case, to show notice of Mr. Faust's address at the time of Miss Baker's death, Your Honor.
Okay, so let me ask you this question, Ms. Cruz. I want to make sure I understand what you're asking to have permission to elicit. Are you asking for permission through that document to elicit information through, as the state has called it, double hearsay, to present evidence of Mr. Faust's address at the time of the incident? And you're calling that notice. Is that right?
No. Let
right.
me make sure I understand your question. Are you asking me if I'm attempting to introduce the document?
No.
Okay.
What I'm asking you is, I want to make sure I understand what you're trying to do. Are you asking to receive permission that the information in the document you gave the state, that the state refers to as double hearsay, about Mr. Faust's address? I'm assuming that, is that right? That's what you're saying is double hearsay is the address? Or the people that said what the address was?
That's right. So
Okay.
there's an individual, a witness,
Right.
says she knows that or believes that Miss Brenda Howard lives at Knollwood Apartments and that Mr. Faust stays with her, and that is relayed to Detective Potter, who then puts it in the police report.
Okay, thank you. And Mr. Cruz, tell me if this is right.
Sure.
That you are asking permission to introduce or elicit testimony about that, what Mr. Yellman-Shirley just said, because under the notion that that information is simply notice to the hearer of where someone lived.
The reader. In this case, it would be the individual reading the document, but correct.
And so you're saying that's just simply notice?
It's non-hearsay because it's notice of Mr. Faust's address at the time of Mrs. Baker's death. Correct. It's just notice. She had notice of that information.
Okay. All right. Thank you for that clarification.
Yes, ma'am.
Mr. Yalamanchili, anything further that you would like to argue?
Not anything further, Judge.
That's not notice. That is a fact that if the defense wants to raise and properly get admitted and properly present evidence supporting that, the defense is able to do that. But that's not notice. That is not the effect upon the hearer. That is a material piece of information or evidence that needs to be proven, as every other piece of evidence in the court of law needs to be proven. And so it is double hearsay. It is not just notice. And I'm not going to allow it, Mr. Cruz, in the form that you're asking to introduce it. I'm not prohibiting that information if you choose to present it in a way that is supported by the law, but not in this manner, not by double hearsay.
Yes, ma'am.
All right, thank you. All right, anything else?
Nothing from the state, Judge.
All right, Mr. Cruz, anything else, sir?
No, ma'am.
All right, you may bring the jury out. Thank you. Wait, hang on one second. Did you need to say something, Mr. Hill? Who wanted to get my attention? I'm
I
sorry.
was going to ask you this.
Yes, hang on a second, sir. Yes.
It's multiple ways I could ask that question, Your Honor. I just want to make sure I don't run afoul of the court's
Okay.
order. So if the court can make clear on the record exactly what I am prohibited from asking, it'll help me make sure I don't offend the court in any way or fail to abide by the honorable court's order.
Well, I mean, I would say that is a difficult thing to answer in that context. The order that I just said orally says that you cannot elicit the information you are asking to elicit in the method that you are asking, for example, by means of double hearsay. And so I don't know if I can be any clearer than that. Double hearsay, unless there is an exception to that, is not allowed.
So I won't ask her about a statement. Is it okay if I ask her if she's aware of information that Mr. Faust did not reside at 350 Cooper Road
Right.
during the weekend of Miss Baker's death?
Before I answer that, I'm going to give the state the opportunity to respond, since we're sort of in this context of proffering and things of that nature. Mr. Yalamanchili, anything you would like to say in response to that query?
Well, I think that the information that he's making reference to is still the double hearsay, Your Honor. So I think it's the same analysis with some semantic changes.
All right. Mr. Cruz, anything further, sir, that you would like to ask the court?
I would just say that doesn't, my position is it doesn't fall under hearsay, but I respect the honorable court's ruling, whatever it may be.
Well, let me ask you this question. The document that you have provided that we're talking about, is that the document that you're claiming gives this agent the information that you're seeking to ask her about?
Correct.
Okay, then I would say that it is barred. I would, just based on my prior ruling. So I would say you can't ask that question.
Yes, ma'am.
All right. Anything else, sir?
No, ma'am.
All right, thank you. You can bring the jury up.
Motion. I have a motion.
All right, you want to do it at the bench, or?
I'll need to do it outside the presence of the jury.
You do?
I do.
All right. Go back to the jury room. Don't talk about the case. Y'all may be seated. Yes, sir.
I'm moving for a mistrial. The state, throughout this case, in opening, they stated that Mr. Faust stayed at 350 Cooper Road. That information is false. It is not true, and it's shown by their own report. Before this trial started, we had Agent Bigham on the stand, and I specifically asked Ms. Bigham, have you reviewed your entire case file? Ms. Bigham said, yes, I reviewed my entire case file. As of right now, Mr. Faust cannot argue consent. Mr. Faust's counsel has been held in contempt due to an interpretation of the rape shield statute that, of course, I disagree with, but I followed honorable court's rulings. But now we're being told not only can't argue a material defense to rape, we're also being told, despite the fact that the state knows that Mr. Faust did not stay at 350 Cooper Road, they are still able to present, please forgive me, Your Honor, I'm talking too fast, but present this false information. And we're being told that we can't confront that information, we can't cross-examine that information, because it falls under hearsay, although it's offered solely to show the fact that the state had notice. Mr. Faust can't defend himself, Your Honor. If we know that the state is presenting evidence that is not true, we should have opportunity to rebut that evidence through this agent. This agent, I anticipate, will testify that Mr. Faust stays at 350 Cooper Road, and he did not. So we don't believe Mr. Faust will get a fair trial. We do believe that ruling is extremely prejudicial because the jury would only be presented with, not even only, they would be presented with information that's not true, Your Honor. So we would ask that the honorable court grant our motion for a mistrial, Your Honor.
Thank you, Mr. Cruz. Mr. Yellow-Mitchell, do you want to respond?
I don't think I need to, Judge.
All right, thank you. Mr. Cruz, I would ask that when we have a recess, you look up the law on what a mistrial actually is and the grounds for it. This is not one of those. The comments that you make do not satisfy the requirements for the court to consider granting a mistrial, so I'm going to deny your motion. I want to respond to a few things that you have said. The prohibition that you have referred to for the courts not allowing what you have referred to as a material defense to a rape allegation is a lot more complicated than the manner in which you have described it. We've talked about the defense's failure to file the appropriate motions that would enable the court to hear whether the information, defenses, or evidence you seek to introduce would actually be admissible. And so that's something we've gone over many, many times, and I know that you know that. And so it isn't simply a blanket decision by the court to not allow certain things, but it is a response to whether the evidentiary and procedural rules have been followed, and I found they had not been. So that's the first thing. With respect to your other arguments, Mr. Cruz, they are best handled by appellate courts. They are not grounds for a mistrial. You will have every opportunity to cross-examine this witness. You will have every opportunity to cross-examine every other witness that you disagree with. But the complaints that you are lodging are not mistrial moments. They are moments for other courts to review. And so I'm going to deny your motion at this time, and I'm going to bring the jury out, and we're going to get started, unless there's something else we need to talk about. Anything else, Mr. Cruz?
No, Your Honor.
All right, thank you. Mr. Yellow-Mitchell, anything else?
Nothing from the
All right, very
state,
good.
Judge.
Can you bring the jury in? Thank you. We're back on the record. Mr. Yalamanchili, you may call your next witness.
Thank you, Judge. The state calls Agent Elizabeth Bigham, who has already taken the stand. Ms. Bigham, will you raise your right hand and take an oath? Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
My name is Elizabeth Bigham, Elizabeth Bigham.
Where are you currently employed, ma'am?
I'm employed as a special agent with the Georgia Bureau of Investigation, and I'm currently assigned to our Office of Special Investigations Cold Case Unit.
Prior to that assignment, where did you work in the GBI?
So prior to this, I spent about 10 and a half years, or maybe just under 10 and a half years, at our Child Exploitation and Computer Crimes Unit, where I worked cases involving the online exploitation of children, child sex trafficking, and child pornography cases. And then prior to that, I was assigned to our Athens field office for about 6.5 years. And I worked general investigations to include anything from homicides to aggravated assaults, thefts, child molestations, etc.
Before you worked for the GBI, did you have any other kind of law enforcement experience?
No, I did not.
Okay. And when you become a GBI agent, what is the training process to become an agent?
So it's changed over the years, but back when I went through the academy in 2007, it was a 14-week basic GBI academy where we did everything from learning law to learning how to write search warrants, emergency vehicle operations, shooting, etc. And then after that, we did a 2-week undercover narcotics school. And then we were sent to our respective field office, and we were involved in a field training program. I don't remember how long it was. It varies because there's basically a field training book, and you have to check off certain things. There's so many interviews you have to do. You have to fingerprint someone. You have to do all these different things. So it can vary in how long it takes. But I would say on average about 6 months or so. And then you're kind of on your own with the help of older agents or more seasoned agents.
As it relates specifically to the Office of Special Investigations, as well as your unit, the Cold Case Unit, when is it and how is it that that unit came into existence?
So our unit was established as part of the Coleman-Baker Act. Our unit was established in July of 2023, and there are 10 special agents that are assigned to that office, and we essentially work cold cases. That's our primary responsibility. And the Coleman-Baker Act was enacted, I don't recall the specific date that it was enacted prior to that, but essentially there's some criteria that you have to meet in order to file a Coleman-Baker application. And those are that the case had to have been a homicide.
Mr. Yalamanchili, do you care to respond to the objection?
Your Honor, it goes back to this witness's training and experience.
Yes, sir.
Coleman Act has nothing to do with her training.
Okay, I'm going to overrule the objection. You may continue.
And Agent Bigham, I think you had just started in on talking about some of the statutory criteria for making a request.
Yes. So the case had to have been a homicide, had to have occurred after 1970. It has to be at least 3 years old, for lack of a better word, or cold if you want to call it that. There are some criteria that indicates that it has to be, or it has to have been investigated by a GBI office if you're requesting the GBI, but also you can request the police department or sheriff's office. That was the initial investigating agency under the same thing. And that the leads and all of the kind of probative leads have been exhausted, and there are really no suspects at that point. And that's kind of the criteria that you have to meet. I believe you have to be a family member as well of the deceased.
When is it that you joined the unit?
I joined October of 23.
And did you, at any point after you joined the unit, were you assigned to review the case of the murder of Tara Baker?
I was.
Okay. Do you recall approximately when it was when you were assigned that case for investigation as part of the cold case unit?
If I'm not mistaken, it was the first case I was assigned
All right.
when I got there.
And was there any other agent who was assigned to that case as well with you?
Yes, Special Agent Jeremy Howell.
Once you received that assignment, and kind of more generally, once you receive a cold case assignment, what are the initial steps that you take and took in this case?
So I don't know that there's a specific way you have to work a cold case every single time. I think it's kind of our preference as well, our agent preference, how you're going to start and what you're going to do. But logically, you'd get the case file and start reviewing the case file. In this particular investigation, it was a bit unique in the sense that Athens-Clarke County Police Department had an extremely large case file, and GBI also had an extremely large case file. So it took a minute to collect all the files, get all the Athens stuff, get all the GBI stuff together, and kind of mesh it all together to figure out where we were at and where we needed to start.
And you mentioned an extremely large case file for ACCPD and an extremely large case file for the GBI. How did the volume of this case file compare to other cases you had worked as either an agent dealing with the sexual exploitation crimes that you made reference to, or prior to that when you were an agent working homicides, aggravated assaults, et cetera?
Mr. Young, would you like to respond to the objection of relevance?
I think it goes directly to the amount of information that Agent Bigham had to review and digest as part of her work on this investigation.
I'm going to overrule the objection. You may continue.
So our GBI case files, before we went electronic years ago when we used to print everything, they're generally about an inch thick, and if I'm not mistaken, there's 25 or 27 of those at the GBI office in Athens. So there's about 27 volumes. We called them a volume, and they were generally about an inch thick. And then the Athens file, if I'm not mistaken, was about 15 4 or 5 inch thick binders of just paper and printouts and things of that nature. And then there were also multiple boxes containing various pieces of the case file, and we kind of had to get it organized a little bit.
And that's just the paper associated with the case, is that correct?
Yes, I would say it was about 20,000 pages or so.
Is it important to review the physical evidence in the case as well?
Oh, absolutely.
Okay. And so is that something that you did as part of reviewing the case file in this case?
Yes. Agent Howell and I, in December of 23, spent a few days over at the Athens-Clarke County Police Department going through every single piece of evidence that they made available to us, which was, my understanding, was everything but one piece, which stayed in the evidence room but was accounted for. And we inventoried it, created a spreadsheet to help us follow it because the Athens evidence had been through, I believe, 3 iterations of an evidence program. So we wanted to ensure that, the barcode it was given when it was first taken in 2001 matched up to what barcode it had now, and it all kind of stayed consistent. We wanted to see if we had any missing evidence. We wanted to see if there was anything that was unaccounted for. So we spent days just going through every piece one by one, documenting it and ensuring that it was present and where it had been and things like that.
That talks about physical evidence in general. I want to talk to you a little bit now about a subset of physical evidence that I'm going to refer to as biological evidence, okay? As a cold case unit investigator, what importance does biological evidence have to you and to your job in investigating cold cases?
So I think that's kind of what we were focusing on initially, because those are the things that we can send back to the crime lab and hope that there's potentially updated testing or new testing. And at that point, it would have been, 23 years or so, that we can maybe get something from. So we obviously noted things that could potentially be retested or tested with new technology that was available.
So you used the phrase 23 years or so, and I mean, I just want to make sure that we're clear about what are you referring to? 23 years from what?
2001.
Okay.
January 19th of 2001.
All right. And so is that a process you went through in evaluating the physical, biological evidence in this case?
Yes, Agent Howell and I documented everything, and eventually we had a meeting with our crime laboratory about that.
Okay. And I don't want you to get into anything anybody said during that meeting, but based on that meeting, did you make a determination about resubmitting certain items of physical evidence?
We did.
Okay. And let me ask this also. Are these things happening one after another sequentially or all at the same time?
It's kind of all at the same time. Well, we're, in December, we're inventorying evidence, and then we're still reviewing the file. And then in, February, we have a meeting with the crime lab. We're still reviewing the file. We're just kind of doing different investigative acts, but all sort of at the same time. And once we do one thing and it's kind of holding for a minute, we move on to some other things.
And as it relates to, besides review, particular steps that you take, as part of your review, do you kind of create an idea of who the witnesses were at the time of the actual crime?
Yes. As we were reviewing the file, we would make notes about maybe potential people we wanted to re-interview just after sort of an initial review of everything or reading it through the first time, and start just kind of keeping notes on what we wanted to do separately from the evidence.
And so as part of y'all's investigative actions in this case, were certain witnesses re-interviewed?
Yes.
Okay. Did you yourself conduct all of those interviews?
No.
Okay. Besides you and Agent Howell, was there anyone else from the GBI who was kind of helping with some of those interviews as well?
Yes. Many of the other agents from our office, and then also some agents from field offices around the state. So, for instance, if we had an interview in South Georgia that was 4 hours away, I would ask an agent to handle that for me.
At any point, did the resubmission of some of that biological physical evidence from January 19th of 2001 yield any new information?
It did.
Okay. And what information is it that you received?
So on April 30th of 2024, we received, and by we I mean Agent Howell and I, received a crime lab report in reference to some DNA evidence. Okay.
Okay. So I'm sorry.
All right.
That's all right. And you did the right thing. And so I just want to take you back to the question there for a second. And it was, what information did y'all receive?
Okay. So as part of that crime lab report, we learned that there was a match to DNA in the sexual assault kit that was taken from Tara Baker at the time of her autopsy.
Okay. And when you say a match, what, was there a particular individual or individuals to whom that match came back?
Yes, it came back to Edrick Faust as part of the oral swabs that were tested out of her sexual assault kit.
Okay. And when you're saying oral swabs, you're talking about swabs labeled as oral swabs.
Yes.
Is that correct?
Yes.
Okay. And was there any other individual to whom a DNA result came back?
Yes, there were additional reports that were issued as well within a very short time period. But we also were informed that there was DNA matching Christopher Melton as well from different parts of the sexual assault kit.
And so I think you already testified this would have been April 30th of 2024. Is that correct?
Yes, when the first match report came out.
What investigative steps did yourself, Agent Howell, or other law enforcement involved in the investigation take at that point?
So after we received Mr. Faust's information, and then subsequently, a few days later, when we received Mr. Melton's information, we obviously knew who Mr. Melton was and started to conduct some interviews. We went and re-interviewed Ms. Hall, or Ms. Peavy, Ashley Peavy, Tara's roommate, went and re-interviewed Ms. Lowe, or Dr. Lowe, Valerie, and started to just kind of go over everything that we had, read in previous interviews through the case file. We looked at the case file again as far as Mr. Faust was concerned to see if his name had ever come up or if there was any reference to anything like that, and we did not see anything relating to him in the case file. So we started to try and kind of familiarize ourselves with Mr. Faust and who he was. We conducted, like I said, some additional interviews, and essentially kind of went on from there.
Okay. Did you ever re-interview Mr. Chris Melton?
We did. We interviewed him on a Sunday morning, I believe it was May 5th.
Okay. In your review of the case file, did you find any information connecting Mr. Faust to Miss Tara Baker?
The only information, no, we could not find any connection between Miss Baker and Mr. Faust, except that Mr. Faust lived 585 feet from Miss Baker's residence.
Okay. And what address is that you had that was 585 feet from Miss Baker's residence?
350 Cooper Road, Athens, Georgia.
Based on what you did up to that point, did y'all make a decision on whether or not to arrest Mr. Faust?
We did.
Okay. And when is it that the arrest was executed?
May 9th, 2024, so about 10 days after we received that report.
Okay. Following your arrest of Mr. Faust, did y'all continue your investigation of this case?
We did.
Okay. I want to talk to you a little bit about your understanding of the DNA evidence back on April 30th of 2024 and in those subsequent couple of weeks. At that point, what was your understanding of the DNA evidence?
Your Honor, based on the court's prior ruling, that would constitute hearsay, so we have a hearsay objection.
All right, Mr. Yelman-Chili, any response to the hearsay objection?
Your Honor, I think asking her understanding of it is not hearsay.
Go ahead, sir.
We had a hearing outside the presence of the jury in regards to the exact same thing. The defense was so that our question is hearsay, that question is hearsay.
I'm not quite understanding your objection, so I'm going to ask why don't you both come to the bench for now? If we have to send the jury out, we will, but let's start at the bench.
Agent Bingham, I'm going to ask my question in a different way, ma'am. When you reviewed the physical evidence in this case, did you identify any swabbings that were labeled any kind of way on the exterior of the envelopes?
Yes.
Okay. In your review of the autopsy and your review of those envelopes, what were the labelings on the envelopes that you reviewed in the physical evidence as related to the swabbings from the sexual assault kit done at the autopsy?
Right. So our understanding was that there were 2 packets of swabs that were labeled oral swabs and one that was labeled rectal.
Okay. Did that seem to, I'm trying to find the right word for this, make sense when taken in conjunction with the autopsy?
No.
Okay. What about it didn't make sense?
Well, the fact that they took, or that 2 packs of oral swabs were taken, one of rectal, but no vaginal swabs were taken, seemed kind of odd. And we knew from reviewing prior crime lab reports that we had vaginal smears that were made back in, I believe, 2001. So obviously, if a vaginal smear was made, a vaginal swab had to have been taken. So our understanding at that point, and from what we learned from the crime lab as well, was that there was something was amiss as far as what got labeled incorrectly.
Is this something that you discussed with the GBI crime lab?
Yes, we did.
After discussing it with the GBI crime lab, did you make a decision about any other labs or testing that should be pursued in this case?
Yes, after consulting with the crime lab, we learned about Pure Gold Forensics and that they were a company that could help us to potentially differentiate between the swabs
And
scientifically.
When you say differentiate between the swabs scientifically, which swabs in particular are you making reference to?
2I and 2J, or 2I is oral swabs B, or swabbings B, I think it says, and then 2J is swabbings A.
Okay, so the 2 things are both labeled oral swabs?
Yes.
Okay. And what steps did you take to facilitate Pure Gold's review of those 2 pieces of physical evidence?
So we had a video conference with, I believe he's the owner or CEO of Pure Gold. I'm not really sure of his title, and explained a bit about the case and what we had going on and what we were looking for, and asked if that was a possibility, if that's something their lab could do. Obviously, we received a quote for how much that was going to cost, and I ended up sending off the cuttings of swabs that were provided to me by our crime lab to Pure Gold for testing.
And now, just to put some dates on these things, when is it that y'all sought help from Pure Gold in order to make a determination about what was actually in each of the oral swabbing labeled envelopes?
I honestly don't remember when we had that video conference. I don't remember.
Do you remember when you received the results from Pure Gold?
I would have to look at the report to see, or my report to see. I don't remember.
Okay.
I want to say it was maybe fall of 24.
Okay. Well,
have to look.
do you think that reviewing that portion of your report would help refresh your recollection?
Absolutely.
And, Your Honor, I apologize. It's going to take me a second to find that particular one. Judge, my computer's frozen, so just it may take a few more seconds. Judge, I'm going to show Mr. Cruz a report dated from September 5th of 2024. By Agent Bigham, sorry. Agent Bigham, I'm going to hand you a laptop that has a copy of your report from Thursday, September 5th of 2024. I'd like you to review it, don't read from it, and let me know when you've had a chance to review it.
Okay.
Having had an opportunity to review that report, has it refreshed your recollection?
Yes.
All right. If you would, please let me know when it is that y'all sent the information to Pure Gold.
September 5th of 2024 is when I would have mailed it to Pure Gold.
Okay. Now, I want to go backwards a little bit and go back to May. Did you re-interview Mr. Chris Melton in May of 2024?
Yes, Agent Howell and I did.
Do you recall what date you re-interviewed him?
I believe it was on Sunday, May 5th. I believe that was the 5th.
Okay.
No, it was a Sunday morning for sure.
And just so we have our timeline, when was it again that Mr. Faust was arrested?
May 9th.
Okay. So going back to May 5th of 2024, that's obviously before the September date we just talked about. Is that right?
Yes.
Okay. So when you went to go meet with Mr. Melton and interview him, where did you believe his DNA had been recovered from?
At that point, we believed that it had been recovered from oral swabs, which would have been taken from Ms. Baker's mouth during autopsy.
All right. And I was not precise in some of my questioning. I've been saying, when did you re-interview him? Had y'all ever interviewed, and when I say y'all, I mean you, Agent Bigham, and Agent Howell, had the two of you ever interviewed Mr. Melton?
No.
Okay.
Had not.
Were you familiar with your review of the previous investigation in the case file, whether or not he had been interviewed before?
Yes.
Okay. Did you have an opportunity to review those interviews?
I did. I reviewed the audio recordings as well as the summaries that were written.
All right. And in your review of that, as well as your review of the case file, did you develop any kind of opinion about the way in which Mr. Melton perceived his interaction with law enforcement from the time period of the original investigation in 2001 and kind of continuing forward?
I guess my perception was that, I mean, obviously he was kind of the first suspect, the first person they looked at, and they continually looked at him for years. Interviewed, I believe, 4 times over the years by different people, different agents, different officers. And our perception was that, you know, he was the one that they were kind of continuing to go back to and ensure that they were getting statements from him and, you know, verifying his alibi and things like that.
Given that he had already talked to law enforcement several times, well, let me back up a little bit and lay a little groundwork. As an investigator who interviews suspects, are there certain interview techniques that you use?
Yes, I think it depends on the type of case, the type of person you're talking to, and kind of what you're trying to glean from the interview.
Okay. Was there any kind of technique or approach, even, technique might be a bad word, that you were intending to use or used with Mr. Melton on that May 5th interview?
As far as that's concerned, I generally do interviews pretty much the same way all the time. They're very relaxed. very casual. It's more like a conversation. I don't get fired up. I'm not a yeller that I can think of in any interview I've been in the past 18, 19 years. So I generally approach interviews like that. I kind of have this rule of thumb that I'm not ugly to anyone unless they give me a reason to be ugly. So with him, it was just very relaxed. I mean, obviously we wanted to talk to him. We wanted to kind of rehash his story and go through everything again. But other than that, I mean, there was no reason to confront him or no reason to be ugly towards him.
And, this might be a hard question, but if you know approximately how many of the original witnesses were re-interviewed as part of y'all's investigation?
Oh my gosh. I mean, I don't know how many were re-interviewed. I would say maybe 20 or 30 off the top of my head.
Okay.
We did well into 100 interviews, I would say, but as far as re-interviews, maybe 20 or 30. I'd have to go look for an exact number.
And I don't want you to get into any of the contents of the interview at this point, but after you arrested Mr. Faust on May 9th of 2024, did you and Agent Howell interview him?
We did.
Okay. And did Mr. Faust provide y'all with a statement at that time?
He did.
Okay. Agent Bigham, I'm going to show Mr. Cruz State's Exhibit 158. After that, I'll bring it up to you. What's that? Mark the State's Exhibit 158. Do you recognize that?
I do.
Okay. And let me ask you this. How do you recognize it?
So it's got a GBI evidence property tag number on it. It's got our evidence label on it. And I recognize the crime lab number that's on it as being this case's crime lab number.
All right. And do you know what is contained in that envelope or baggie?
I do.
Okay. And what is it?
It's, I'm assuming a box. Yes. Buccal swabs that were taken from the mouth of Mr. Faust.
Okay. And so when you say Mr. Faust, were you present when those samples were collected?
I was. It was Agent Howell and myself.
All right. Did you collect them or did Agent Howell collect them?
No, Agent Howell did.
Okay. But you were present when it was collected, is that right?
Yes.
Okay. And were you present when it was placed in that evidence bag?
I remember him boxing them up. I don't recall if he put them in a bag where we were right then.
Okay.
But boxing them up, they go inside of like a white cardboard box.
All right. And when you say Mr. Faust, do you mind pointing to the individual who you saw those buccal swabs taken from and describing an article of clothing that that person is wearing if they are present in the courtroom today?
Sure. So he is sitting over at the table over there by the door, and he's wearing an Argyle sweater that's light blue, teal, and gray.
And, Your Honor, I'd ask the record reflect that Agent Bigham has identified Mr. Faust.
It so reflects.
All right. And I'm not going to tender this exhibit through Agent Bigham. Your Honor, we'll connect up the rest of it with Agent Howell. If I could have just a moment, Judge.
Okay.
Your Honor, I don't have any other questions for Agent Bigham at this time.
All right. Mr. Cruz, cross-examination.
Good afternoon, Agent Howell.
Bigham.
Excuse me. Good afternoon, Agent Bigham. Please forgive me. You have opportunity to sit in the courtroom during the entirety of this trial. Is that correct?
Yes, it is.
And you've had the opportunity to hear everyone's testimony?
Yes.
You've had the opportunity to hear my opening. Is that right?
Yes.
The state's opening.
Yes.
Mr. Melton testify.
Yes.
Ashley P.B. Hall testify, as well as Valerie Lowe.
Yes.
On Sunday, May 6, 2024, you and Mr. Howell interviewed Chris Melton. Is that right?
I believe it was Sunday, May 5th.
Thank you for that. So Sunday, May 5th, you interviewed Mr. Howell. Excuse me. I am sorry.
Mr. Melton.
Mr. Melton, please forgive me. And you met with them at the Walton County Sheriff's Office. Is that correct?
Yes, it was one of their satellite precincts.
And you knew during the interview, Chris volunteered that the longest he had gone without seeing Tara before her death, it was 10 days because of work. Is that right?
That's what he indicated initially in the interview before we helped refresh his recollection based on his original statements that were given immediately after the homicide.
And you asked him whether Tara slept at his parents' house the Saturday before her death. Is that correct?
I believe I did.
And Chris told you for a second time, no, I hadn't seen her for like 10 days beforehand or something.
Yes, we went back and forth through the 10 days and the 5 days and what was originally stated and whatnot.
Sure. And during your conversation, you told Chris, I don't have it on this, but I think what you said is that she slept at your parents' house the Saturday night before, and then she left Sunday morning, and that was the last time you saw her. Do you recall making that statement to Mr. Melton?
I don't recall that specifically. I'm not sure what the I don't have it on this is.
Can you repeat that for me?
I don't recall specifically making that statement. I can reference my summary if you'd like, but I don't understand the part where you said I don't have it on this. I'm not sure what I was referencing during the interview.
Sure, and I'll simplify the question. You recall telling Chris that he previously said that Ms. Baker slept at his parents' house the Saturday before her death.
Can I reference my summary
Of
to
course.
verify that?
Of course.
So I have that. I referenced the original interviews with him and that he told law enforcement back then that he last saw Miss Baker the Sunday prior to her death.
Can you repeat that?
I referenced my notes that I must have written myself some notes that I had back then during that interview, and I relayed to him that he told law enforcement that he last saw Miss Baker the Sunday prior to her death. And I do believe, yes, that was at the parents' house, his parents' house.
And Mr. Melton's response to you was, that doesn't sound right either. Is that correct?
I don't recall if that was his specific response, but he kept going back to the 10 days. He kept thinking in his head it was 10 days.
Multiple times, is that correct?
Yes.
And can we agree that Mr. Melton told you at least 3 times that the last time he saw Miss Baker was 10 days before her death?
I don't remember how many times he said it, but I do know we had multiple conversations about it.
Sure. Would hearing your audio recording refresh your recollection?
Sure.
Court's indulgence? And let the record reflect that I'm going to refresh Agent Bigham's recollection from minute mark 1457. Excuse me, 1 hour, 14 minutes, 57 seconds through 1 hour, 17 minutes, and 6 seconds. And just to make sure it's clear, what we're looking for here is Mr. Melton telling you 3 times that he hadn't seen Ms. Baker for 10 days prior to her death. Is that fair?
Yes. Can we move this? Okay. Yeah.
So you'd agree within that timestamp that was previously stated, you have heard Mr. Melton state at least once that he hadn't seen Ms. Baker for 10 days?
Yes.
Okay. And we've heard a second time that Mr. Melton puts the last time he's seen Ms. Baker at least 10 days before her death.
Yes, he states it's the weekend before.
The weekend before her death.
Before, yes.
Okay. All right, and within that 2-minute and 8-second time span, Mr. Melton has said at least 3 times that he has seen Ms. Baker for the last time 10 days prior to her death.
Yes.
And for the third time, you told Chris that you last saw her Sunday morning when she left. Do you recall making that statement?
Yes, based on the previous interviews.
Okay. But you're reminding him that previously he stated that he saw Tara the weekend before her death. Is that right?
Yes, we were refreshing his recollection.
Okay. And Mr. Melton told you a fourth time that it had been 10 days since he last saw Miss Baker. Is that correct?
I don't recall if he said it a fourth time.
Let the record reflect that I'm refreshing Agent Bigham's Would hearing the recording refresh your recollection? Yes. Okay. So we're going to do number 4 and 5, okay?
Okay.
So let the record reflect that I am playing minute mark 1 hour, 20 minutes, and 10 seconds to 1 hour, 21 minutes, and 57 seconds, Your Honor. Okay, you've heard for a fourth time Mr. Melton state that he believes it was the weekend before her death. Is that correct?
Yes. Okay. So he told you at this point at least 5 times that he had not seen Miss Baker for 10 days prior to her death. Yes.
And this is after you've told him multiple times, or repeated to him multiple times, what he told law enforcement in 2001. Is that right?
Yes. I think he was processing, we were kind of going back and forth, like he was processing, you know, what he recalled and the fact that it's 24 years later at that point. So.
You then asked Chris, and I believe this is the 5th time you asked Chris, so was there ever a time in those 10 days, whatever, leading up until her death that y'all just had a quick booty call or met up real fast or anything like that? Do you recall asking that question? And for the 6th time, Mr. Melton stated that he had not seen Miss Baker within 10 days of her death.
Said that he had not been with her, I believe, the week of her death.
Mr. Melton's response was not no.
I don't recall specifically, but I remember the further we got into it, I recalled that he was saying, because we were going down the path of, did you see her at any point for a booty call the week of her death? We were trying to figure out and narrow that timeline, and he said no.
Let me make sure I'm clear on my question. The question that you asked him was there any time within that 10-day window that he met up with Miss Baker for a booty call? Would you agree on that?
I don't remember saying the 10 days. If I did, that's fine.
Sure. Would hearing the recording refresh your recollection?
Yes, I did state that it was in the 10 days. Had y'all had a booty call or met up real quick or anything like that?
And he said no.
And he said no.
Okay, so now we're at time number 6 that Chris Melton has told you that he has not seen Ms. Baker 10 days within her death. Is that correct?
That's correct.
Okay. Now, you would agree that you told Chris that you know that he's been dishonest with police for 23 years.
I don't remember telling Chris he had lied to police for 23 years.
Do you recall telling Chris, I need you to be 150% honest with me?
Yes.
Okay. And you explained, I know that what I'm about to ask you is not what has been said for 23 years, and that may hinder you from wanting to be honest with me. Do you recall making that statement?
Something along those lines, yes.
And you then told Chris, but we're here because there's been some evidence that's come up that you can't really argue and say, I was with her 10 days prior. Do you recall making that statement?
Yes, something along those lines.
And then you shared with Chris, there's been some DNA that's come back to you. Is that fair?
Yes.
And this was before you told him. So what that leads us to believe is that perhaps you were with her at some point sexually, much closer to her death, and this is the language I emphasize, than has ever been let on. Do you recall making that statement?
Not specifically, but I do remember having that conversation with him.
Would hearing the recording of your statement refresh your recollection?
Sure.
So I asked that question just to make sure the record is clear. So you told Mr. Melton, so what that leads us to believe is that perhaps you were with her at some point sexually, much closer to her death, and I emphasize this language, than has ever been let on. Is that correct?
Yes.
And at the time of the interview, you received a DNA report on May 2nd, 2024. Is that correct?
I did.
Okay, and the interview with Mr. Melton was May 5th, 2024. Is that right?
Yes.
And the reason you knew Mr. Melton's DNA was present in her mouth is from the May 2nd, 2024 DNA report. Is that correct?
Between the April 30th and the May 2nd reports, the swabs that the DNA had come back to were labeled oral. So that's what we believed at that point.
Sure. But the report from May 2nd also stated that Mr. Melton's DNA was present in Ms. Baker's anus as well. Is that right?
Yes.
Okay. And you were aware, as the lead investigator in this case, that Ms. Baker had been sexually assaulted. Is that fair?
Yes.
And you would agree that DNA lasts in the mouth for up to 12 hours. Is that correct?
I can't speak to that. I'm not a scientist. I have an understanding in what I was told, generally what can occur, but I can't speak to specifics about how long DNA lasts in someone's mouth.
But you told Mr. Melton that it lasts for 2 to 3 days. Is that right?
I don't remember specifically what I told him. I'm not arguing with you about it. I just don't remember specifically what I told him. But I do know that we had some information about how long it could last.
But we know it wasn't 10 days. Is that
correct? That was not the information we had at the time. Okay. We did get information later.
And we could also agree that DNA doesn't last in the mouth 5 days.
I'm not going to speculate to that. I'm not a scientist. I don't know.
That's fair. But we did know Mr. Melton's DNA was in her mouth.
No. Mr. Faust's DNA was in her mouth.
Okay. So is your testimony here?
You're talking about at that point?
Correct.
Oh, at that point, we believe that we knew it was on the oral swabs or a pack of swabs that was labeled oral at that time. And yes, that's what we believed at that point.
Fair. And you have access to the GBI's DNA experts. Is that right?
Yes.
So they could tell you, hey, either this should be here or this should not be here. Is that correct?
As far as what?
How long DNA lasts?
Yes, generally.
Now, despite this, you assured Chris Jeremy and I are not here because we think you killed Tara at all. Is that a fair statement?
Absolutely.
And you tell Chris that his DNA was in a place that makes sense for you two, but doesn't make sense for bad guy.
Yes, because he was her boyfriend.
And bad guy is Mr. Faust.
That's who was identified through the CODIS match.
And just to make sure, you didn't know Miss Baker. Is that correct?
No.
And you tell Chris, we have bad guy's evidence there, but we got to separate those two. Do you recall making that statement?
Something along those lines, yes.
And it is fair to say, despite acknowledging that Chris lied for 23 years, you were asking Chris to help you explain away his DNA to pin Miss Baker's death on Mr. Faust.
I don't believe that Chris lied for 23 years. I reviewed his statements that were given the day of Tara's death or murder, and 2 days later, and those statements were consistent and made more sense, especially with the new evidence that they had sex 5 days or so prior to her death.
Sure. So my question is this. If you don't think he was being dishonest, why would you make the statement so that leads us to believe that you were with her at some point sexually much closer to her death than ever has been let on?
Because when we were interviewing Mr. Melton, we obviously had this new information from the crime lab, and we're under the impression that it shouldn't last more than a few days or somewhere in that vicinity. At that point, we kind of were going with the information we had on that day at that point. Of course, that can change once evidence is processed and more things are done to it.
Objection narrative, Your Honor.
Overruled. So we were going with what we had at that moment, and now I've totally forgotten your question. I'm so sorry.
Sure.
Can you repeat it?
My question was that you told Mr. Melton that, court's indulgence, I want to make sure I give you the proper question. But you told Mr. Melton that that DNA evidence led you all to believe that he had been with Miss Baker some point sexually, much closer to her death than has ever been let on. Is that right?
That's right. Thank you. So at that point, we're going with the information that we had in the moment from the crime lab reports, speaking with the crime lab personnel, etc. And we were re-interviewing Mr. Melton to obviously just go over the statement and go through all the things again, but also to ensure that there was nothing we were missing. Is there some reason that, he did have a booty call or go meet her for a quick, quick meetup or anything like that had just never come out before? And we were trying to explain why, or this evidence and why it was there. I mean, obviously we knew that's her boyfriend. It should be there, but we were trying to get the timeline down.
So, at this point, we agree that you had Mr. Melton's DNA in Miss Baker's mouth and her anus. Is that fair?
Are you speaking of that day?
Correct.
At that moment, that was the information we believed because both of the packages were labeled oral.
And during your interview on May 5th with Mr. Melton, Mr. Melton told you that him and Tara did not engage in anal sex. Is that correct?
That's true.
And we also had Mr. Faust's DNA in her mouth. Is that right?
That's true.
So at this point, we can agree that the evidence against Mr. Faust at this time that you have is DNA in Ms. Baker's mouth.
No, at the time they had processed the other set of oral swabs, and that came back with Mr. Faust as well.
So my question is, the evidence that you had against Mr. Faust is DNA in Ms. Baker's mouth. Is that right?
At that moment.
And at that same moment, we had Mr. Melton's DNA in her mouth. Is that right?
Yes.
DNA in her anus. Is that right?
Yes.
And also a statement from Mr. Melton that him and Ms. Baker did not engage in anal sex. Is that right?
That's right.
And just for the purposes of this, Mr. Melton was not arrested at his May 5th interview. Is that right?
No,
Okay. You did not obtain warrants from Mr. Melton based on this information. Is that correct?
no, we would have no reason to.
But you explicitly told, or would you agree that you explicitly told Mr. Melton, well, I think Jeremy would agree with this. I don't want to speak for him, but like we are here to try to separate you from the killer. Is that fair?
Probably something along those lines.
Okay. And you were speaking again of Mr. Faust.
At that point, that was the other information we had.
Okay. Based solely on his DNA in her mouth.
No, at that point, I mean, that was, what, 5 days or so? And we had already been working on and reviewing the investigation again. We had Mr. Faust's name 5 days prior to the interview with Mr. Melton.
Let me ask you this, because it's not a trick question. I'm not trying to trip you up or anything. When we're talking about physical evidence, the only physical evidence you had connecting Mr. Faust with Ms. Baker is Mr. Faust's DNA in Ms. Baker's mouth.
Yes.
But on this May 5th interview, although we have more physical evidence involving Mr. Melton, you tell Mr. Melton you want to separate him from Mr. Faust. Fair?
Right.
We've agreed on that.
Mr. Melton had an alibi.
You then asked Mr. Melton for the 6th time, so was there ever an instance closer to her death that you just went over and got a blowjob, that y'all met up real quick, just get a little quick rump out? Do you recall making that statement? Okay, and before he answers, you tell him, because 10 days before, there's not still going to be sperm. Like literally scientifically, it doesn't last in your mouth. Is that correct?
Or I said something like that.
Okay. So at this point, you aren't even interviewing Mr. Melton as a suspect. Is that fair?
No, he wasn't being interviewed as a suspect because he's had an alibi for 20-something years.
And you also make clear to Mr. Melton, but we have to separate you from the bad thing that happened and make sense of the thing that would be understandable and normal. Is that correct?
Something along those lines.
So can you explain to me how Mr. Faust's DNA being in Ms. Baker's mouth and Mr. Melton's DNA being in Ms. Baker's mouth and anus, although Mr. Melton stated they don't engage in anal sex, makes it understandable and normal? Can you explain that?
My understanding through speaking with the crime lab is that there's something called drainage and gravity. I mean, we all know what gravity is, but drainage, and that you can, that semen or sperm can drain down from the vagina to the anus, and that can be a possible way that it gets into an anus. And yes, while at that point, we still had 2 packs of oral swabs, we knew or had a belief that one of those was vaginal swabs. We just didn't know which one it was yet.
Let's talk about drainage. So we've established, at best, Mr. Melton says it's been 5 days before since him and Ms. Baker had sex. Is that fair?
Yes.
And we would assume, I know you say that you don't know Ms. Baker, but Ms. Baker would take a bath every day. Is that right?
I don't know specifically, but my understanding from previous interviews is that she would shower in the mornings.
Okay, and that's daily, right?
I believe so.
Okay. So your position is, and correct me if I say it wrong, we know Ms. Baker was sexually assaulted anally. Is that right?
Yes.
We can agree that in the May 2nd, 2024 report, Mr. Melton's DNA profile is the only identifiable profile. Is that correct?
In the May 2nd report?
Correct.
No.
I would like you to look at the 5th paragraph on the first page of the May 2nd report from Dr. Ashley Hinkle, please.
I don't have it.
I have it for you.
I mean, I have notes regarding it, if that's
And I could give you the whole thing, or I could give you the pertinent page. Which one do you prefer?
what. Either way.
I give you the whole thing.
Okay.
Your Honor, I'm going to object. My understanding, Ms. Cruz hasn't said anything about refreshing recollection or anything along those lines. And it seems that he's asking Agent Bigham to testify off a report that she did not create. So I'm going to object.
All right.
But on direct examination, Agent Bigham testified that she was aware of the DNA report from May 2nd, 2024. So she's already established her knowledge of same. I asked her if she was aware that Mr. Melton's DNA was the only identifiable DNA in Miss Baker's anus, and her answer was, I believe, no, I do not recall that.
Oh, I don't.
Okay.
Correct me.
So-
Please correct me if I make a mistake.
Was that your answer?
Well, I'm sorry. I may have misunderstood you. I don't remember you specifying her anus. I thought you were talking in general about the DNA. But if you're specifically talking about the rectal swabs, then yes, you're absolutely right.
I'm going to let you
Sorry.
re-ask. Let's do this since there's been an objection, but I think maybe this witness was confused by your question.
Sure.
If you'd like to ask the question again, you may do so.
Yes, ma'am. Mr. Melton's DNA profile was the only identifiable DNA profile in Miss Baker's anus.
Yes.
Okay. In the state's theory and law enforcement's theory of how he's the only DNA profile is that it was drainage.
That was a theory that was proposed to me,
Okay, that's a theory,
or just a way that it can happen.
a way to explain away Mr. Melton's DNA so you could focus on this. Is that right?
No, I don't think that's accurate.
Form of the question, it's argumentative.
I'm going to sustain that objection.
Yes, ma'am. And you also told Chris that in order to separate him from Miss Baker's murder, we got to figure out that timeline and clarify it, or it doesn't make any sense. Do you recall making that statement?
Something along those lines.
And you would agree that to a reasonable person, it could appear that you're asking for Chris Melton's help in pinning Miss Baker's murder on Mr. Faust. Is that fair?
Object, Your Honor, calls for speculation.
I'm going to sustain that objection. I don't think it's a proper question. You may rephrase, Mr. Cruz.
Yes, ma'am. What you're trying to do, is it fair to say that you're trying to explain away why Mr. Melton's DNA was in Miss Baker's mouth? Is that fair?
No, I'm trying to get an understanding of why it was in her mouth, because that's what we thought at that time.
Okay, so let me ask you this. We've already agreed, you and I are aware, that Mr. Melton was aware that Miss Baker was sexually assaulted. Is that right?
I'm sorry, say that again?
Sure. We both are aware that Miss Baker was sexually assaulted. Is that correct?
Yes.
You didn't find it odd when you told Mr. Melton about DNA in Miss Baker's body. His response was, I'm taking in that there was something else in her, somebody else's stuff there too.
Mr. Melton, during that time, once we started getting into the specifics of the evidence that we had and what the questions we were asking him, he was starting to become kind of very distraught and almost just kind of like in shock. I remember talking about that with him, like, I was in shock as much as you're in shock. You know, like, he was trying to process everything, and I took that sort of statement as him sort of processing everything that we were talking about.
Sure. And that's your interpretation of his statement. Is that
That's
fair?
my interpretation.
Okay. But after you made that after Mr. Melton made that statement, Chris tells you for a seventh time, like, as far as, you know, the 10 days is stuck in my head. Is that correct?
Again, I think at that point he's sort of reeling and processing everything and trying to kind of make sense of this information that he's now learned after 20-something years.
Agent Bigham, this is your investigation. Is that correct?
Myself and Agent Howell?
Okay, but you are the lead investigator. Is that correct?
Sure.
Okay. And because of your work, this prosecution was brought against Mr. Faust. Is that correct?
Because of our work.
Sure. But you wouldn't want to do anything that would hurt your chances of convicting Mr. Faust. Is that right?
I just want to work a case to its proper conclusion and convict the right person.
Well, sure. And that's an excellent point. When we talk about convicting the right person, you would agree that when you obtained arrest warrants for Mr. Faust, the only evidence you had of his connection with Miss Baker was DNA in Miss Baker's mouth. Is that fair?
Yes, that was the only evidence we had of their connection.
Okay.
They had no other reason to be connected.
Sure, but physical evidence, just DNA in the mouth.
That's correct.
Okay. But for Chris Melton,
I apologize. At the time of arrest?
physical evidence, correct.
Yes, yes.
But for Chris Melton, we've already established that we have DNA mouth, DNA anus, and a statement from Mr. Melton saying that they did not engage in anal sex. Is that right?
That's That's accurate.
But based on your determination, the right person to arrest is simply the person whose DNA is in her mouth.
It was Mr. Faust.
And Mr. Melton.
No, I'm talking. You said the right person to arrest, and I said
Sure.
it was Mr. Faust.
And Mr. Melton, because Mr. Melton's DNA was in her mouth as well. Is that right?
It was, but Mr. Melton had an alibi.
And you would agree that you told Mr. Melton you were shocked to learn that his DNA was present.
Yes, I believe I said something along those lines.
Okay, you explained to him, and in my thought, when I got this news, and I was about as shocked as you are right now, last week, you were a 23-year-old kid, you were being hammered by the effing cops that are treating you like S, after you've just found out your girlfriend's been brutally murdered. Is that correct?
Yes, I remember making those statements.
And then you continued. You stated, and you're terrified knowing, yeah, y'all had a booty call. She got back from the library that night. You came up. She went down to have a booty call real quick. And in your head, you're like, I was literally the last person with her.
That was an interview tactic, I guess, or technique, whatever you want to call it, that I was using to just try to give him one more opportunity to let us know if something had occurred that week. Like, just basically putting into context for him, like, you were a kid and, you were scared and the cops were going after you and things of that nature, and just trying to give him an out to give us that information. But he stuck strong to his statements that he was not with her that week at all.
And he also stuck strong to his statements that he hadn't seen her in 10 days as well. Is that correct?
By the end of the interview, we had come around, and he agreed that with the prior information or information from his prior recordings that I had listened to, that he agreed that it was accurate, that he had had sex with her, or they may have had sex on that Sunday before she left his residence, which would have been in that 5-day marker.
Yeah, and I would ask for the opportunity to get my answer from the witness, because we are on cross. Excluding the narratives, another report said that the witnesses are allowed to narrate after they answer a question.
No, they're allowed to explain, Mr. Cruz. So tell me what your objection is. Do you have an objection?
I'll make the objection when it takes place, Your Honor. I think
All
that's
right.
the appropriate way to handle it.
All right, go ahead, sir.
But then you told Chris, you didn't kill her, but you were the last person there before she got killed. Do you remember making that statement?
No, I do remember making that statement, but that was in the context of me giving him that narrative of the last, or giving him an out with that narrative. That was not separate, nor was I telling him he was the last person with her. It was in the context
Objection,
of that
narrative, Your Honor.
I'm going to overrule that. I think she's explaining her answer to you, Mr. Cruz. So I'm going to overrule that objection.
And you continued, and so in my mind, it makes complete sense that you would be omitted from the conversation because you don't want any more pressure on you. They are already hounding you enough, and you know that you didn't kill her, but you knew you were with her. You would agree that's an accurate statement?
No, that was my narrative that I was giving to him to use as a technique to try to give him one last opportunity to tell me that he was with her, if that was the case. But again, it was not.
Well, this is an interesting thing. You've already told us that when you interviewed Mr. Melton, you weren't interviewing him as a suspect. You were just interviewing him to have a conversation with him. Is that right?
Yeah, that's right.
So giving him a justification as to why his DNA was present when it should not have been, would it be fair to say that you were justifying or trying to explain away his DNA with him?
No, I mean, his DNA should have been present. He was her boyfriend at the time.
Sure. And
I wasn't giving him a justification. I was ensuring that we...
Objection, narrative, Your Honor.
I'm going to overrule that objection. You've asked a question. She's answering your question. I'll allow her to answer.
I was ensuring that we... trying to think of a good word to use. I was ensuring that we clarified everything in his statement and interviewed him in the best way possible before we started kind of moving on to Mr. Faust. And obviously we knew going in that he had an alibi and he did not kill her. but we were trying to do our best to explain this DNA with what we had at that moment.
And despite you explaining or giving him a way out, Chris still doesn't change his timeline from 10 days. Is that correct?
No, I believe I already stated that towards the end of the interview, he agreed that they would have had sex on that Sunday before she left his parents.
Let me specify the question. After you told Chris you know you didn't kill her, but you were the last person there before she got killed, and so in my mind, it makes complete sense that you would be omitted from the conversation because you don't want any more pressure on you. They're already hounding you enough, and you know you didn't kill her, but you knew you were with her. Chris's response was, that's the tough part. Like, I don't recall being with her between the time.
I would have to listen to it, but I mean, we don't have to. I'm just saying that again is the narrative that I was kind of spewing to him to see if he was going to say anything else before we concluded this interview.
So my particular question.
But no, I don't believe it was accurate.
My particular question is, after you made that statement to Chris Melton, he still did not change his timeline from 10 days.
He was still kind of reeling all the information and he was almost like having a conversation with himself.
Objection, non-responsive.
Overruled. You've asked her a question and she's answering it. I'm going to allow this witness to answer your question. Agent Bingham.
I'm done.
Is that a yes or a no, Agent Bingham?
You'll have to ask me your question.
Sure. After you gave him the statement about him not being the killer, and specifically, you know you didn't kill her, but you knew you were with her, Chris still did not change his timeline from 10 days. Is that correct?
I don't believe that's accurate.
And you've heard portions of this interview. Is that correct?
Yes.
Okay. And you recognize the interview because it's your interview with Mr. Chris Melton. Is that correct?
Yes.
Based on the portions you heard, had that interview been altered in any way?
I only heard minutes of it.
Sure.
I would assume not, but I can't speak to that.
So I'll let you hear minute mark 128:16 to 128:43.
Yeah, he said.
But that is a fair and accurate portion of your statement or your conversation with Mr. Melton on May 5th, 2024.
Yes, a portion of my conversation.
Okay. And for that particular portion, which is minute marks 128:16 to 128:43, you recognize that particular portion. Is that right?
Yes, I do.
Okay, and it hadn't been altered in any way to your knowledge.
I don't believe so.
Your Honor, I would move to introduce minute mark. Well, excuse me. Let me show the state. Please forgive me.
All right.
I don't have any objection, Judge.
All right. And what is, there's no objection, but you, Mr. Cruz, tell me what you want to admit.
Sure.
All right.
As Defense Exhibit 47, I am admitting minute mark 128:16 through 128:43
Right.
of Miss Elizabeth Bingham's conversation with Mr. Chris Melton on May 5th, 2024.
It is admitted.
And may I publish same
May.
procedure, Your Honor? You're still on the.
Real quick, and you in your head like I was killed. You were the last person there before she got killed, and so in my mind it makes complete sense that that would be omitted from the conversation because you don't want any more pressure on you. They're already hounding you enough, and you know you didn't kill her. But you knew you were with her.
That's the tough part. Like, I don't recall being between the times. Like,
So again, Mr. Melton is telling you he does not recall being with her in between that time. Is that correct?
Right, and at that point, he's just reeling over all this information. He's visibly upset to the point where we got him tissues. And just kind of processing all this information. So we're going back and forth about it.
You said you two were going back and forth about it?
Like that's what we had been doing, like back and forth as far as like going like him talking about the 10 days, me talking about what he previously said, things not in an aggressive or argumentative way.
So it got to a point where Mr. Melton, as we've agreed, has stated multiple times that 10 days was the last time he saw Ms. Baker. Is that right?
Like I've said, I believe towards the end of the interview, we came to an agreement that they had sex Sunday before she left his parents' residence, which would have been the 5 days.
Sure. So my question is, during the interview, at some point, Mr. Melton continued to say that he hadn't seen Ms. Baker for 10 days. Is that right?
Yes, he said it multiple times.
And at a certain point, you would agree that you and Jeremy Howell started pressuring Chris to change his answer. Is that right?
No, we were just talking to him and trying to refresh his recollection and explain to him that what he said the day of her murder and 2 days, or I'm sorry, 2 days after her murder, I apologize, was that they had sex 5 days prior.
Okay, and you interviewed Mr. Faust, is that correct?
Myself and Agent Howell did.
But Mr. Faust didn't get that same benefit, did he?
We didn't get that far in the interview.
Did Mr. Faust get that benefit, yes or no?
And Judge, I'm going to object. The interview is not in evidence, and the defendant is not allowed to elicit possible self-serving hearsay.
I didn't.
Response, Mr. Cruz.
Absolutely. This officer has personal knowledge of the interview as she was present. And I didn't ask for any hearsay statements, Your Honor. I just asked if Mr. Faust received that same benefit.
Okay, I think that Mr. Yelmanchili's statement is a correct interpretation of the law. I'm going to sustain the objection.
Yes, ma'am. But our last question was that you and Mr. Howell began pressuring Chris to change his timeline. Is that correct?
I don't know that I'd call it pressuring. We were, again, utilizing interview techniques to try to elicit information if it were any different than what he had been providing for 20 some odd years.
Okay. Well, I asked you about that earlier, and you stated that you didn't believe Chris Melton lied 23 years earlier. But now you're saying that...
No, we didn't. We were trying to explain the DNA and trying to understand why it was there.
So would you agree that the statements that Mr. Melton had given for 23 years prior was inconsistent with the DNA you had in Ms. Baker's mouth?
That's hard to answer because at that moment, because we believed that that was her oral swab, that was the oral swab.
At that time, May 2nd, we're talking about
That's
May
what I'm
2nd.
trying to think through. Can you ask me the question one more time? I apologize.
Sure. The statements that Mr. Melton had given for 23 years was inconsistent with the information you had regarding his DNA being in Ms. Baker's mouth.
Yes, I guess that would have been inconsistent at the time with the information we had in that moment.
Sure. But Chris has asked, despite this conversation and him saying 10 days, he has asked, is there even a percentage of a chance you were with her Thursday night? Is that correct?
I'm sure I said something like that.
Okay, and Chris responded no.
That's correct.
He was then asked, not even a 1% chance? Is that correct?
Yes,
Chris again responded no. Is that right?
that's correct.
And despite him saying no, 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 he is then asked again, even Wednesday night. Is that correct?
That's correct.
And Chris responds no.
That's correct.
However, despite Chris saying no, law enforcement tells Chris, I understand you're saying you don't recall.
Are you saying we told him that?
Correct.
I don't remember.
You don't remember making the statement, excuse me, you don't remember Mr. Howell making the statement, I understand you're saying I don't recall?
I don't. I mean, I'm not arguing with you that he did make the statement, but I just don't remember that specifically.
I'll let you listen to the portion just to make sure it's accurate, okay? Your Honor, may I approach the
You
witness?
may.
Do you recognize Agent Bigham?
I do. That's Agent Howell speaking.
Okay, but you're present as well, is that
Yes.
right? Okay.
Yes.
And did that recording sound like it had been altered in any way?
No.
Okay, and we've already established that this is the May 5th, 2024 interview with Mr. Chris Melton.
It is.
Okay. Your Honor, I would move to admit minute marks 1:28:58 through 1:29:10 into the record.
Is this D48?
No, this is the same exhibit. I'm just marking different points that would be admissible, and I'll give the court reporter the portions that'll be admitted.
I think it's probably best we just call it 48.
D48. How will we sticker it?
I'm not exactly sure at this point, but just for the record, to be clear, these are two separate
Portions.
entries,
Sure.
and it can be the same thing. And just so it's recognized that they're two separate entries, the last one is 47, this is 48.
Yes, ma'am.
Is there any objection?
Yes, Judge. I took Mr. Cruz's original action to be refreshing the witness's recollection, which she stated she was refreshed and then testified consistently with the statement. So I don't know that there's any reason to admit it for publication in front of the jury as a prior inconsistent statement, which seems to be what Mr. Cruz is planning on doing here.
All right, Mr. Cruz, you care to
May I
respond?
respond? Sure.
Yeah, of course.
The question I asked her was just personally to make sure that she recognized that so I could lay the foundation for a prior inconsistent statement. Her statement to that question was, or to my last question that led to this, was in regards to despite Chris saying no, Chris was told, I understand you're saying I don't recall. And her response to that was no. So I laid the foundation as a prior inconsistent statement, and we're asking for admission as saying.
Okay. Mr. Yalmanchili.
That wasn't her response. Her response was, I don't recall, at which point Mr. Cruz played this statement for her, and then she responded, yes, that is Agent Howell. So,
I mean, I think that's accurate. I don't think we're dealing with the prior inconsistent statement. I'm going to sustain the objection.
Yes, ma'am. So, however, despite Chris saying no, he's told, I understand you're saying I don't recall.
No, when I listened to that just now, my understanding of what Agent Howell was saying was, I understand if you don't recall. That's how I interpreted what Agent Howell was saying.
Sure. Your Honor, I would ask to admit minute mark 128:58 through 129:10 as a prior inconsistent statement. Or
That's
it's
my
two,
interpretation.
impeachment by contradiction as well. So I think this one would fit more so under impeachment by contradiction.
All right. Mr. Yalmanchili, any response?
I just have the same response as I had before, Judge.
I think based on the witness's statement, Mr. Cruz, you have not proved that this is a prior inconsistent statement for purposes of admission. You may be able to admit it later, but for this specific purpose, I'm going to sustain the objection.
Okay. Is this sustained in regards to impeachment by contradiction as well?
Yes.
Okay. Understood, Your Honor. Now, during your questioning, you have no reason to disagree that Chris changed his timeline from 10 days to 5 days. Is that fair?
We talked about it towards the end of the conversation.
Okay. And with that conversation that you had with Chris, you told Chris, but I think what you said is, and I believe we talked about this, is that she slept at your parents' house the Saturday night before, and then she left Sunday morning, and that was the last time you saw her. Is that accurate?
Yes, that's accurate.
And Chris is then told that you and Jeremy have to be able to explain his DNA and that he needs to be within a certain window or you can't explain his DNA. Is that correct?
I'm not going to argue with you that it's not. I'm sure it is. But we were, again, trying to explain to him that we've got to understand why this DNA is in here
Okay. So
in a certain window.
did you have to explain it for Mr. Faust?
Again, we didn't get to that point.
Okay. Did you try to explain it for Mr. Faust?
We didn't get to that point in the interview.
We're going to sustain that objection.
Thank you.
At the time you interviewed Mr. Faust, you already had a...
Again, Judge, he can't reference this interview without it being admitted, and as the defendant, he can't admit it.
Judge,
Mr. Cruz and Mr. Yalmanchili, may I see you at the bench, please? Thank you. I think it's... Yes. Let me ask that question.
At the time of your interview with Mr. Faust, you had already secured arrest warrants. Is that correct?
Yes.
So in regards to Mr. Faust, we have DNA in Ms. Baker's mouth, and based on that, Mr. Faust, an arrest warrant is issued for Mr. Faust for murder. Is that correct?
Yes.
Okay, felony murder. Is that correct?
Yes.
Burglary. Is that correct?
Yes.
Arson. Is that correct?
Yes.
Aggravated sodomy. Is that correct?
Yes.
Okay. But Mr. Melton's DNA is in Ms. Baker's anus, and an arrest warrant isn't issued for Mr. Melton for sodomy. Is that right? It isn't issued for murder?
No.
Despite acknowledging that Mr. Melton may have said something for the past 23 years that wasn't consistent with the DNA evidence that you had on May 5th, 2024.
I don't. Was that a question?
Yes, ma'am.
I'm sorry. You'll have to rephrase.
Sure. Now let me ask you this way. Despite having Mr. Melton's DNA on May 5th, 2024, okay, and despite knowing his statements for the past 23 years were inconsistent with the DNA evidence that you believed you had on May 5th, 2024, an arrest warrant was not issued for him.
No.
Okay. Now let me ask you this. Do you know Mr. Melton's family?
No.
Okay, so you don't know if he's related to anybody?
No.
Okay. Does he have any family in law enforcement that you would know of?
No idea.
So just based solely on Mr. Melton, I'm assuming being Mr. Melton, an arrest warrant isn't issued for his arrest.
Mr. Melton had an alibi that made it impossible for him to kill Tara Baker.
And you've been in the courtroom each and every time we've talked about Mr. Melton's alibi. Is that correct?
Yes, but I also reviewed it in the 20,000 plus page case file in multiple interviews over the years.
And you'd agree that once Mr. Melton is told that window we're in is we have to be able to explain why you are where you are just as much as we have to explain why someone else is there as well. But it's a narrow window, and it can get complicated if your window is greater than the window of expectation for how long evidence could be there. And that's what we're trying to drill down into. The further in time you are from how long this could last, the more complicated and less reasonable that explanation is. Do you remember Mr. Melton being told that?
Did I say that, or did Agent Howell say that?
Mr. Melton was told that.
I'm sure he was. I don't recall if I said that or if Agent Howell said that.
But once that statement was made, we can agree that Chris then says, if anything, it would have been maybe that Sunday, the weekend before. Is that correct?
We had been talking about that the entire time because I had continually refreshed his recollection on the statement he gave 2 days after Tara's murder.
So, Ms. Bigham, my question is, after that statement was made to him about his DNA, his response was, if anything, it would have been maybe that Sunday, the weekend before. We would have done something Sunday morning before she left. Is that accurate?
Yes, he did state something along those lines.
Now, Ms. Bigham, we've agreed that Chris Melton stated that Ms. Baker spent the night at his parents' house the weekend before her death. Is that right?
Yes.
Okay. However, you would agree that nowhere in your case file or in no report that Mr. Melton's parents ever confirmed that Ms. Baker stayed at their house the weekend before her death. Is that correct?
I do know they were interviewed. I don't believe they were asked about that, but I would have to look at the report to be certain, but I don't believe they were asked about her spending the night.
So the answer to my question is a yes. Is that correct?
Well, yes, they were interviewed.
So my question was that Mr. Melton's parents never confirmed the information that Ms. Baker was at their home the weekend before her death.
I believe that's correct.
And you cannot show the jury any report confirming Mr. Melton's claim that Ms. Baker was at Mr. Melton's home the weekend before her death.
No, I don't recall seeing anything there.
In fact, law enforcement simply took Chris's word for it. Is that correct?
I Wouldn't say they took Chris's word. They conducted additional interviews with alibi witnesses, for lack of a better way of saying it.
Objection, non-responsive, Your Honor. My question didn't involve alibi witnesses.
I'm going to overrule the objection. I think this witness is allowed to explain her answer. You may follow up with any question.
Sure.
They conducted interviews with additional witnesses that could confirm where Chris was on Friday morning. Their focus was on Friday morning. That was law enforcement's focus back then.
This is your case file. Can you show the jury where that information is in your case file?
Where what information is?
That Mr. Melton or anybody confirmed that Ms. Baker was with Mr. Melton the Saturday before.
I never said that they confirmed that.
Okay, so that isn't confirmed. Is that right?
No, I never said that. I said that law enforcement focused on his whereabouts Friday morning. Friday morning of her murder.
So based on the information you had on May 5th, whether that window was 12 hours, a couple of days, you would agree at the time of Miss Baker's death, Chris Melton's DNA being in her mouth would suggest that he had been dishonest about the last time he saw Miss Baker.
We believed at the time of the interview that it was in her mouth. That was later determined to be incorrect based on additional crime laboratory testing that we did.
Let's talk about that because I believe you've mentioned that a couple of times. So I would like to hone in on that. And is it okay if we have a discussion about that?
Sure.
Okay. Now, we've agreed that you told Chris, or Chris was told, that law enforcement needed to be able to explain his DNA. Is that fair?
Yes.
Okay. And it is fair to say that Mr. Melton would not put himself with Miss Baker within the week of her death. Is that fair?
That's correct.
Okay. You would agree that by removing Mr. Melton from her mouth and putting Mr. Melton in Miss Baker's vagina, it changes the timing window. Is that correct?
My understanding is the window that sperm can last in the vagina is different than in the mouth.
Which would allow you to explain Chris's DNA. Is that right?
Once we determined that those were indeed vaginal swabs, it definitely made more sense.
Okay. You would agree that you did not obtain the result. Well, excuse me. The testing that you did was with a California company. Is that right?
Yes. With
Okay.
Gold.
And we're in Georgia. Fair?
Yes.
We're on the East Coast. Is that correct?
That is correct.
Pure Gold is on the West Coast. Is that right?
That's right.
And you heard Ms. Lycon's testimony?
I did.
And she stated that multiple labs throughout the United States conduct this type of testing. Is that fair?
I believe she said that.
Now, we could agree that we didn't move Chris from the mouth to the vagina until November 4th, 2024. Is that right?
Is that when the Pure Gold report was issued?
Unfortunately, I cannot answer any questions.
If that's when the Pure Gold report was issued, then that was when we got confirmation that those were vaginal swabs.
Would you have any reason to disagree that report was issued November 4th, 2024?
I don't, but I would have to look at it to be 100% certain.
Now, you mentioned confirmation that it was vaginal swabs, but Ms. Lycon herself said this is a presumptive test. There is no confirmatory testing. Would you agree?
Yes, she did speak to that.
Okay. So for the benefit of Mr. Melton, the mouth swab was turned into a vaginal swab based on a presumptive test. Is that fair?
I would say it was for the benefit of the investigation, not for Mr. Melton specifically. But we needed to figure out which ones were vaginal swabs because we knew from the vaginal smears that one of those packs had to have been vaginal swabs and they were just mislabeled.
Well, this is the thing. You would agree there have been a lot of mistakes in this investigation, right?
I'm not going to speak to other potential mistakes.
Well, you've been in the courtroom with us. We had an incident. You remember the incident where we opened the package, the state admitted, and it was empty, but it was supposed to contain hairs. Do you recall that?
That was the package that the hairs were collected in. Once the hairs go to the crime lab, they get mounted on slides.
Sure. How about the clock? Did you hear the testimony about the clock being lost?
I don't remember the clock being lost.
That's fine. How about the screen? Did you hear the testimony about the screen being lost?
Oh, absolutely.
Do you all have possession of Miss Baker's house keys?
I don't believe so.
So Miss
As
Baker's,
far as the GBI is concerned, I
Correct.
don't believe so. And I don't remember seeing them during the evidence inventory.
So, Ms. Bakers, let me make sure. You're saying that you never had a set of keys from Ms. Baker?
I don't believe so. I don't recall seeing a set of keys
From Ms. Baker, is that correct?
from Ms. Baker.
Court's indulgence, Your Honor.
I can look through the evidence list if you'd like me to.
Please do, and I'll look through the one that we have as well.
Are you speaking of Elvis key ring with 2 keys, Tara's apartment?
I am.
Oh, I mean, it says we did check it actually. I just don't remember.
So do you have possession of Ms. Baker's keys?
No, I do not have possession.
Okay, where are Ms. Baker's house keys?
I don't know. They were in the possession of the Athens-Clarke County Police Department on December 11th of 2023. I apologize. I don't remember. There were 180 something pieces of evidence that we inventoried.
Sure, that's fair. Do you have the lock to Ms. Baker's home?
I mean, we don't have, I don't believe we have everything. I think Athens-Clarke County Police Department has all of the evidence. I do recall the lock. Yes, the deadbolt from the front door. Is that what you're speaking of? Yeah, that was inventoried and we checked it on December 11th.
Do you have possession of that lock in the courthouse here today?
I have no idea. I'd have to go look.
Do we have possession of those keys in the courthouse here today?
I have no idea. I'd have to go look.
All right, but you stated that you are the lead investigator on the case with Mr. Howell. Is that fair?
Yes.
Excellent. So I want to talk about the physical evidence from Ms. Baker's house based on your investigation and your decision to get an arrest warrant. We can agree that no hairs in the home were connected to Mr. Edrick Faust. Is that fair?
Yes.
Okay. If you could write under arrest warrant secured, no hairs. And we could also agree in regards to Mr. Melton's hair, his hair was found on the cord used to strangle Ms. Baker. Is that correct?
No, that's incorrect. It was found on the, I think people keep calling it the power transformer box for the printer. Now, the cord of the printer was utilized to do that, but if I'm not mistaken, it's on the power transformer box.
And that power transformer is connected to the cord that was used to strangle Ms. Baker. Is that correct?
Yes, that's my understanding.
As far as fingerprints, I'm sorry. Attorney Hill, if you were right, hair on, and make sure I put this right, Ms. Bickham. I want to make sure I get this accurate, okay? Put hair on under melon, correct. Under anal. Hair on weapon. Is that fair? Power cord was used as a weapon?
It's on the power transformer box. It was not on the cord.
That was connected to the cord, is that right?
Sure.
Okay, fingerprints. None of Mr. Faust's fingerprints were found in the house. We could agree on that.
That's correct.
Okay. And I won't go into the interview. I'll save that. But at this point, the evidence we do have, DNA, mouth, anus, Mr. Melton did not engage in anal sex. Mr. Melton, hair on power transformer connected to the cord used to strangle Ms. Baker. Is that fair?
Yes.
We also have a mitochondrial DNA test that states that the pubic hair found on Ms. Baker's butt could not eliminate Mr. Melton as the contributor. Is that correct? And that's from 2007, from lab court.
And you say that it couldn't eliminate Mr. Melton? I'd have to look at the report again to refresh my recollection.
Sure, and I believe it's already in evidence, so that's fine.
Okay.
But you did not have any hairs that was in your GBI or ACCPD's custody tested for DNA. Is that correct?
No, we did not.
Okay.
In 2024 or 3 and beyond.
Okay. You had the swabs and you solely went off the swabs. Is that correct?
No, after meeting with the crime lab that in February of 24, we went through every piece of evidence. The meeting was hours. We went through every single piece of evidence with each section head of each area. So hairs and fibers, DNA, latent prints, etc. And went through all the evidence and talked about all the evidence, what had been done on it in the past, what could be done on it in the future, or not in the future, but now. Had any technology changed or been updated that would be valuable to retest or to help retest these items. And that's how we determine what we could resubmit versus what couldn't be resubmitted because either maybe the technology wasn't there or nothing, they've already done everything with it and there's nothing else to do, things like that.
So can you tell the jury what items of Mr. Melton's were, well, let me rephrase that. What items were resubmitted for DNA testing? Because I understand that you all's position is the reason we have the DNA is because of new technology. Is that fair?
Yes, newer technology.
Okay.
That's my understanding.
Excellent. But we can agree that no DNA testing took place of the unidentified hairs. Is that fair?
Yes, but there was reasons for that. Some of them were not suitable didn't have a route suitable for DNA testing, et cetera. I have an explanation for some of the hairs.
Sure, that's fine. Now I'd like to ask you this, and I'll end on this note with you. And I won't go deep into it, but we've talked about the DNA in the mouth and anus. Is that fair?
Yes.
Okay, and we've already agreed that you were armed with that information. Is that correct?
Some of that information on the second.
And despite being armed with this information, you told Chris Melton, but that's why it doesn't matter. If you're like, you know what? I effing lied about it 23 years ago because I was a scared, terrified kid. And you're right. I had a booty call with her that night. I left at midnight. I don't know what happened after that. It'll be, thank you, have a nice day. We'll let you know what happens. Laughs like that's it. Is that a correct statement from you?
Yes, because Mr. Melton had an alibi that would have made it impossible for him to kill Tara.
And you explained to Chris again, we just want to be able to explain it and make it make sense so we could focus on this. Is that correct?
Yes.
Okay. Thank you. Those are my questions.
Any redirect, Mr. Yellow-Chili?
I don't have any redirect questions, Judge.
You may step down.
Do you want this or do you want me to leave it?
You can leave it with the court reporter.
All right, ladies and gentlemen, it is 5 o'clock. Perfect stopping time. We are going to stop the trial for today. I'm going to release you, ask you to return, of course, tomorrow at 9 o'clock. Please don't talk about the case. Do any independent research. Go to any of the places that you have heard about in this case. And, of course, as I talked to you about yesterday, I know I keep repeating the same instructions, but it is important. Certainly try to avoid all social media that could show you some things about this case that were taken up outside your presence. That certainly would not be appropriate for any of you to see, which is why we do things, of course, outside your presence. I know sometimes it probably seems really difficult for you to get up and get down. I know I mentioned this yesterday, and I'm sorry about that. It is very important, however, to have certain proceedings outside your presence, and I appreciate your patience in all of that. With the thanks of the court, you're all excused for today. We'll see you tomorrow morning at 9 o'clock. Anything else, Mr. Yelman-Chili, Mr. Cruz, we need to take up before we release everybody for today?
Nothing from the state, Judge.
Mr. Cruz, anything, sir?
No, ma'am.
All right, thank you. I'm going to ask the media who are here who have our badges. We're going to let the bailiff collect them, so they'll return them to you all tomorrow. It'll help us kind of keep track of who is here. I appreciate your cooperation so much. Thank you. Thank you. Court is adjourned. We'll see you all tomorrow morning, 9 o'clock. Thank you.